see live stream. All rise. Pierce County District Court is now in session. The Honorable Jeffrey Yons is presiding.
Thank you. Please be seated.
Good morning, Your Honor.
Good morning. This is the matter of the State of Washington versus Edward C. Troyer Jr., Pierce County District Court case number 1AC 002225. My name is Jeffrey Yons. I am a Kitsap County District Court judge who has been appointed visiting judge to preside over this case. These proceedings are being live streamed through the Pierce County District Court website. Viewers are reminded, however, that they are prohibited from photographing or audio or video recording these proceedings without the prior permission of the court. This prohibition also applies to courtroom observers. The live stream feed is showing on the large monitor to the observer's right there. Only credentialed media, which have been granted permission from the court in advance, are permitted to photograph, audio, and or video record these proceedings as outlined in the court's November 4, 2022 media coverage order. To courtroom observers, jurors have a duty to decide this case based only on the evidence presented. To ensure that both parties receive a fair trial, it is my duty to minimize the risk that jurors are influenced by external factors. For this reason, courtroom observers are prohibited from wearing clothing or accessories that with political or social justice messaging. If you are currently wearing or displaying anything that meets that description, please cover it up or put it away. Thank you for your cooperation. And good morning. Anything from the state?
No, Your Honor, thank you.
Preliminarily? Defense?
Yes, Your Honor, a couple of preliminary matters. We filed a motion last night with the court relating to the testimony of Officer Wallace.
Court has received the motion. Thank you.
Thank you. And we'd like to have that addressed. Do you want to do that now? Well, any time before he testifies, but it may as well be now, Your Honor. The second thing was we have two preliminary matters as to Mr. Altheimer relating to the motions in limine.
Okay, so
It was based on the state's one of their oral motions in limine.
okay.
And
Well, let's
that's
first deal with the matter that was filed. It's a motion that the defense has filed. I got a copy of it this morning. I had a chance to read it. The one main case that was, there's a lot of cases cited in there, but one main case dealing with the issue was the State versus Ruiz case. I had the staff print that this morning and provide a copy to both counsel so you would get a chance to look at it as well. Is the state at this time ready to proceed on that motion?
Yes, Your Honor.
Oh, all right.
I mean, we're ready, but I wonder if it would be better to call the first witness, take a break, and then during the recess, argue them. Well, we want our recess too.
My preference would be to wait until just before Mr. Lawless's testimony. I've had a chance to read the case once, but I want more chance to read it, and then of course I want the benefit of your argument before I would make a decision on that. The parties may be ready, but I'm not quite ready yet to proceed on that. I haven't had a chance to review the deposition, so I'm grateful the defense attached that because there certainly was a discussion in there that Mr. Lawless's attorney and I went through, and actually defense counsel and prosecution, and I've highlighted that, but I want to make sure that I adequately found all the argument that was made about the Fifth Amendment in that transcript, because I think that's going to be a factor in the motion today with respect to whether or not it was a valid assertion of the Fifth Amendment during that deposition. And that, I want more time to look at that, so I'm going to hold off on that issue until after we have testimony this morning from a different witness. And defense, you mentioned two motions concerning Mr. Altheimer.
Sorry, one point of clarification on what you just said regarding Officer Lawless's deposition. The court made rulings throughout the deposition. Is the court saying that the court may be rethinking some of those rulings, or?
Oh, no.
Okay.
no. It's just, the court made some rulings in there, and as I understand the defense argument, from just, again, reading what you've done one time, it was that it was not a valid assertion. And so I want to go through what I ruled to see exactly what I said in the deposition concerning whether it was a valid assertion or not. And I want time to look at that, plus then, of course, your argument about that. So, no, those rulings are, I'm through with those. Those rulings are whatever they are. I just want to make sure that I have a chance to look at them to see whether that was my basis or not.
Thank you.
Okay. Defense,
Actually, then I would ask then, I'll ask to reserve what I have as to Mr. Altheimer and listen to his testimony first, but it does relate to their oral motion and animus toward police.
so you want to raise it before cross-examination?
Exactly. Thank you, Your Honor.
State, any objection to that?
No, Your Honor, I guess then we would take a recess after direct and then hear a motion?
Your Honor, just depends. I'm just saying that I'm not going to raise it right now.
All right.
Thank you.
Understood.
If the defense is ready to go into cross-examination without raising any particular issue, please do so. Depends upon how long this may take. We may be near a break anyway.
Right.
But certainly if the defense wants to raise something before cross-examination, if you let me know, I would excuse the jury, and then we will be able to fully discuss whatever the defense wants to raise.
Thank you, Your Honor. We're ready to proceed.
All right, and state as well.
State as well, thank you, Your Honor.
All right, if you'd please bring the jury back. I was notified all the jurors have returned, so we're fine.
This better not amplify. This is actually amplifying. It hasn't amplified in the past. It hasn't amplified in the past. It's just helped
The jury is entering the courtroom. Thank you. Everyone may be seated. And the state, your next witness.
Thank you, Your Honor. State calls Sedrick Altheimer to the stand.
Raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth? Yes, I do. Have a seat, please. State your name and spell your last name.
I'm Cedric, and my last name is Altheimer.
Ms. Stratnick.
Thank you, Your Honor. Good morning, Mr. Altheimer.
Good morning.
Mr. Altheimer, how old are you?
I'm 26.
And what do you do for a living?
I deliver the newspaper.
And how long have you been doing that?
About 8 to 9 years now.
Does that mean you were doing that in high school? We have an,
Motions in limine. Court's orders.
Overruled.
and Mr. Altheimer, we have an audio record. I saw you kind of nodding, but you need to answer audibly.
Yes.
Okay. So when you started delivering newspapers, was that in high school?
Yes.
And how did that come about?
Family.
And I'm going to need to ask you.
Family.
Well, that'll work, all right. Do other members of your family deliver newspapers?
Yes.
Objection. Relevant, Your Honor, 401, 402, 403.
Overruled, the court will give some leeway.
And which papers do you deliver?
Tacoma News Tribune, Seattle Times, New York Times, and the Wall Street Journal.
And what days of the week do you currently work?
Actively Monday through Sunday, Fridays off.
Have you always worked a 6-day week?
Never.
Okay. And why is that?
It used to be every day of the week.
Can you move the microphone up and then you don't have to move it?
Okay.
Does that help?
Yeah, I didn't know I could move it.
We're all getting used to the audios here. When you're delivering newspapers, how do you know where to go?
You're given a subscribers list.
And how many routes do you work?
I had 3 at the time
At the time being,
of the incident.
and what's on this subscribers list?
Addresses.
And does each house get the same papers?
It just depends on what they want.
And how do you know what papers to deliver to what house?
The subscribers list, it has the labels or initials of what paper to deliver.
Now, when you are delivering newspapers, can you describe from the beginning to end what your routine is in doing that?
Start from bottom and go. Ask me that again. What do you mean exactly is my routine?
From when you leave your house
Okay.
to go deliver your papers, what's that process?
Casually wake up, brush your teeth, go warm up the car, and then drive to a warehouse. Papers might be there, might not be there, so I wait for the truck to be there, and then I go inside and prepare my papers, get my numbers right, and then I head out to my route.
And where's the warehouse?
At the time, it was on 19th and State.
Okay, has it moved since then?
Yes.
You said the newspapers might be there or they might not be there. When do you generally arrive at the warehouse?
So typically, I'm one of those to get in and get it done. So I show up around 11 and usually gone by 11:40.
And do you mean AM or PM?
It's a.m. when I show up. Or p.m., I mean, sorry.
Are you nervous?
Yes.
You want some water?
I mean, I'll take some.
It wouldn't kill you, right?
Objection to the comments, Your Honor. This is a criminal trial against my client, Sheriff Troyer.
Yeah, I'm offering him water.
Overruled.
Thank you.
Do the newspapers always become available at the same time every night?
No.
And why is that?
I can't really answer that. I have no control over that part.
Okay. And about how many papers do you typically deliver each day?
At the time, I had over 400.
And about how long does it take to deliver 400 papers?
I'll say it takes me about an hour for each route, so 3 hours.
And how far apart at the time were these 3 different routes?
2 are literally right next to each other, connecting, and then my third one I drove down by Stadium.
When you're working your route, are you alone?
Yes.
Are you always alone?
Yes.
Do you ever have company with you?
It just depends.
Are you always working alone, though?
Yes.
You said that when you get to the warehouse, you prepare the papers. What does that mean?
Some days there's inserts and some days there isn't.
And once you have the papers delivered, once you have the papers, how do the papers get to each house?
I drive and deliver.
I'm going to need you to talk up.
I drive up to the houses and I deliver them.
Does every paper get delivered to the same part of the house?
Me, I pull in driveways, and if I can get it to the porch, I get it to the porch. If I can't, I throw it in the front of the garage.
And when you enter a driveway, do you keep your lights on or off, or does that vary?
It never varies. I keep them on, or I even turn on my high beams.
And why do you do that?
Because of the year and the make and model of my vehicle.
Can you explain that, please?
I was driving a 1995, so my headlights aren't the best. So I would turn my high beams on to get a brighter view of the street.
Okay. And do you keep them on throughout your route?
Yes.
What are newspaper tubes?
It's a blue tube that says the News Tribune on the side, and it can either be connected to somebody's mailbox or connected to their house.
Do you ever put the newspapers in the newspaper tube?
At the time, yes.
And why do you do that for some homes?
Some homes are just elderly and people want it closer to their door. Have to step outside in the conditions.
Do you ever exit your car when you're delivering newspapers?
Yes.
And why is that?
To get a more accurate throw on the house.
Do you throw them into the newspaper tube?
If they have a newspaper tube, I can't throw it in there, but I walk up and put it up there.
Mr. Altheimer, when you are delivering newspapers, are you ever, do you ever encounter the police or civilians who are wondering what you're doing?
Yes.
How common is that?
I'll say like twice a month.
And I'm sorry, I don't mean to laugh, but how do those situations resolve themselves?
It just depends on who it is and how they are acting that night.
Okay. Can you tell us, let's break this down into civilians and uniformed police.
Okay.
When you are observed by uniformed police, what generally happens?
They
Objection, Your Honor, spade as to time and circumstances. What generally happens when he's followed by a police officer on his route?
Overruled, he may answer if he knows.
It's more of they stop, observe what I'm doing, watch me, and then maybe turn on the light to get my attention to ask me what I'm doing, and then either they decide what they want to do from there.
What about civilians?
They're more vocal. They approach you, ask you, what are you doing? Or either they sit in their car and just watch you from a distance, but they won't talk to you. They just are just watching you. They just pull up and watch you. You drive off, they pull up and follow you again without even talking or saying anything. They're just watching you and following you in their vehicle.
Have you had any encounters with civilians that went beyond that?
Yes.
Okay. Can you tell us about that, please?
It was about 3 years ago. I turned onto a block, and there was a man on the corner, and he got in his car after observing.
I know the court doesn't do sidebars, but I don't think I can answer that without them.
I guess I can withdraw it and hear a little more, Your Honor, but it's not really relevant to this case and the charges against Sheriff Troyer.
Court will give a little leeway on. This is not discussing the incident, is that correct? This is-
No, but I think it'll become clear.
The court will give a little, so objection overruled without prejudice, and I'll give you a little bit of leeway.
Thank you, Your Honor.
Go ahead, Mr. Altheimer.
Go ahead with the story.
Yeah.
So I hit the block. I have 3 houses on his near street of where his house is located, and I pulled into each driveway. Pulled into one, and there's one directly behind me, so I just back up and pull in their driveway, depending on where their vehicle is parked. And then I had one more tube at next door. And as I did those 3 houses, this man was getting in his vehicle and driving towards my way. And as I got down to the next section of the block, the van came speeding down the block, like really fast, trying to find me. But I already, delivered my papers and got to the next block, and you can just hear a loud roar, just engine roar down the street like no other. And he was following me. He just wanted to know what I was doing, who I was. So I called the cops because I wasn't getting out of my vehicle, and I didn't deliver any more papers within that block. I just circled the block with a van following me until the cops showed up.
And what did the police do when they got there?
I would object to move to strike on the same basis as previously stated, Your Honor.
Again, maybe we need a recess.
I don't want to take the jury's time for this, Your Honor, necessarily, but it's not relevant to this criminal case.
It goes directly to a motion. Sorry, I did not mean to interrupt.
I'm done.
It goes directly to a motion in limine, Your Honor.
Members of the jury, at this time, I'm going to have you go back into the jury room. Do not discuss this case with anybody, and no answer.
Do I stand too?
Yeah, you can stay.
That is a good question, not necessarily.
Yes, we do. I'm with you, and yes, we do.
The jury has left the courtroom. Thank you. Everyone may be seated. You may be seated too. Mr. Track.
Thank you, Your Honor. Your Honor, the court explicitly ruled over the state's objection, as I would remind everybody, that prior incidents where he has been stopped by the police or civilians are admissible. That was their motion. We objected to it, and the court ruled that that would come in. And it included the defense wanting to bring in a witness named Josh Harris, which they interviewed Mr. Altheimer again. And the court held that whether or not Mr. Harris would be able to testify would be that you would reserve on that because it could be possible impeachment depending on how Mr. Altheimer testifies. So I'm simply asking the questions that they asked in motions in limine to bring in.
All right, Captain Brown. If I could have a moment, Your Honor. What?
Of course.
It's a different one. I think at this point, Your Honor, there are other circumstances where he's had run-ins with civilians, and so I think it opens the door. I don't know why this was elicited on direct, but I would just state that for the record. And I didn't want to have the jury excused, as I stated, but I don't see the relevance of this. But it is in, and I think that we have an opportunity now to ask about other run-ins that he's had, including with Mr. Harris. And that was the subject of some of the motions.
Your Honor, if the defense doesn't see the relevance to this, then let's not ask these questions. But if I don't get to ask them, they don't get to ask them either. This was their motion in limine to bring in prior run-ins that Mr. Altheimer has had. The state objected to that happening, and the court overruled us. So if I'm now hearing that we're not gonna go in to prior events, that's great. And you can even instruct the jury to not consider that. But this is the evidence they wanted brought in, and that doesn't mean that they get to bring it in. I can bring it in too if the court has ruled that it's admissible.
Your Honor, it was allowed for impeachment purposes for us to use. And we had never heard of this incident. We've had multiple documents regarding interviews that the Attorney Generals have had with this witness. Not raised in any of that. We had one failed interview, then a second interview, not mentioned during that. And so this is the first we've heard. It was our motion, and the court then made a ruling pertaining to impeachment by us. And that's our memory of the order in limine on that. And this was not provided in discovery under Criminal Rule 4.7. Thank you.
Incorrect, Your Honor. This was explicitly asked about during the interview. Ms. Bremner had stepped out of the room to make some phone calls. This interview was done by Mr. Conrad, who specifically kept asking about prior incidents. Mr. Altheimer talked about the incident with John Harris, and he talked about this incident in front of Mr. Conrad. We have our notes, which he described as a road rage incident, where he called the cops, and that's what he's testifying to. I will state under oath that that is what happened during the interview with Mr. Conrad from their office. Ms. Bremner had stepped out. So it's clear she didn't hear that, and I want to be clear about that.
I have to go back and look at our notes on that for the detail, Your Honor. I didn't just step out. I had a hearing in court, a Zoom hearing. So it's our position, this is for impeachment only, and that this will open the door to Mr. Harris and other incidents. And again, I don't want to take the jury's time. It's out now. We've made our objection. The testimony is before the jury, and I'm told that there was a reference to it when I was in court. So for that, I apologize to counsel in the court. And that's all I have.
Again, the court ordered, I don't know what else to say, that the court granted their motion that this would come in, so here it is. It hasn't opened the door to anything. The court's already said that these prior incidents are coming in, so I'm bringing them in.
Just one final thing is that this court excluded the evidence except for impeachment. This is not impeachment. This is direct exam of a witness. Thank you.
That's not the state's understanding of the ruling. The reason the state felt that this was inadmissible evidence is it's trying to conjure up this history of why Mr. Altheimer, I mean, I was here during the motions in limine, would somehow apparently be just so enraged by these prior incidents that he, I think ticking time bomb was the word that we used, that by the time he encountered Mr. Troyer, that he just exploded. That's the offer of proof that they made. We objected to that. So that's not impeachment evidence. And again, if the defense wants to take a different position and say that this should not come in as substantive evidence, that's great, because that's what the state argued and lost.
Your Honor, no one used the terminology ticking time bomb. I've made my record. It's for impeachment. That was the order of the court. Impeachment would be our questioning, not the state's. Thank you.
But he can't be impeached on the Josh Harris incident if he's not asked about it.
Is this the Josh Harris incident that we're...
No, but he's going to get to that.
I have nothing further, Your Honor. Thank you.
This actually arose in the state's motion in limine. In the state's motion in limine G5, within that motion in limine, the state asked the court to exclude testimony from Joshua Harris. Is that the person we're talking about here, Joshua
Yes.
Harris?
No.
And in
Not in this incident, Your
No,
Honor.
but with respect to the motion in limine G5, that again was the state's motion in limine. The court, there was the court recalled there was lengthy discussion about this particular topic, and the court had actually provided counsel the case of State versus Orrin, and with respect to the depth to which a defendant would be permitted to cross-examine a material witness in the case. And the court ordered, and this was under G7, the court created a G7 to make it clear, the state's motion to exclude certain cross-examination questions of Mr. Altheimer's prior conduct with others concerning his newspaper route would be permitted on cross-examination. And that was the court's order, and that was concerning the Joshua Harris motion in limine to exclude his testimony. The state certainly has the ability to choose to enter that information in its case in chief. It was the court's intent that this would be something defense, well, and not the intent, the defense is going to be permitted to raise this topic if it chooses to do so during cross-examination. Court's not heard anything with respect to this other incident that Mr. Altheimer has just testified to. It's being brought in as substantive evidence, which the state choose to do. It is not in violation of any of the motions in limine. The state has a right to do this, and so the defense motion for relevance is overruled because the court was going to allow the state to get into prior incidents with individuals concerning Mr. Altheimer's newspaper route on cross-examination, and so the state can go into this. But since this was not an incident that was discussed in the motion in limine, here we are today on this matter, and if there are other incidents that are intended to be raised concerning Mr. Altheimer and his newspaper route that haven't been discussed in motions in limine, if the state's going to raise them, there's no reason the defense shouldn't be able to cross-examine about them. And so the court is not in the position to know how many incidents there may or may not have been, and that's fine. I wouldn't expect you to necessarily tell me that. But at least with respect to the topic that's been opened from the state with respect to this incident that Mr. Altheimer just testified to, the defense is going to be able to have full cross-examination of that incident. Whether that opens a door to other incidents, and that it's premature to say that because the state may or may not pursue other incidents not related to the specific incidents in this case, and I'll just have to hear what their questions are, and then the breadth of any objections if the defense has them, but then ultimately the breadth of cross-examination on the incidents that may be raised by the state as substantive evidence in their case in chief. So the objection's overruled. State's opened this, and so if the state wants to continue asking on this line, that's up to the state to do that, but then certainly the defense can be allowed to cross-examine on this topic, as well as when the court had discussed Mr. Joshua Harris. And this ruling is based upon State versus Orn. We talked about that before, and our state Supreme Court has made clear that it is a trial court's duty to make sure the defense has a full opportunity to cross-examine a material witness in a case. And state brought this issue up, and so the defense should be able to cross-examine about it.
Thank you, Your Honor.
You did mention, the defense did mention that this information may be of surprise, and I don't know if you have more motions about that,
No.
or
Not right now, Your Honor. I'll check with our team here, but at this point, none to raise right now.
any questions from the state?
No, Your Honor, to let the court know where we're going, we're going to ask them about the Mr. Harris incident next, and that's the extent of what we'll be bringing in,
About other incidents?
involving civilians.
Would those incidents involving civilians now be open to incidents involving the residents and Mr. Altheimer, not just people that followed him, that he claimed followed him?
I would like you to bring that up after direct
All right.
examination if you want.
I will do that.
Because I haven't heard, again, do not assume I know these, because I don't. And so it's hard for me to rule on something I haven't heard. Mr. Altheimer has not been asked about it or any testimony about it. And so I'm reluctant to rule on something like that in a vacuum without knowing specifically what the evidence the jury has heard, and then I'll decide whether or not other incidents should be permitted. And that would be something we'll do outside the presence of the jury if it's something beyond what's been asked in direct examination.
Perfect. Thank you, Your Honor. That's all the defense has.
Anything
on
else?
this.
No, Your Honor, thank you.
Please bring the jury back.
Right.
Mr. Altheimer, if you need a break or some water, just let me know.
It works like that?
Yeah, you can.
Your Honor, while we're waiting for the jury, I can't see the witness from where I'm seated, so per the court's prior order, is it okay if I move at certain
Yes.
times? Thank you, Your Honor.
And that'll be a standing order as well with respect to any exhibits or the witnesses.
Thank you.
The attorneys may move so that they can observe.
Thank you, Your Honor.
Jury's returning to the courtroom.
No, they know that they're.
Thank you. Everyone may be seated. The defense objection is overruled. Ms. Stratton.
Mr. Altheimer, when we left, you had finished talking about this incident where you called the police. Was there a second incident where you were followed by a civilian?
Yes.
And can you tell us about that incident, please?
So I was parked in the driveway, delivering the paper. I might have took a minute or two because I had to get things situated. But then a black SUV turned onto the block and noticed me in the driveway and took into his own perception that I was breaking into his truck that was parked in the driveway. And then he followed me down a block. And then we got to the next block, and I had to get out to throw a paper closer up to the door for the customer. And the black SUV pulls in between my car in the street and the sidewalk. He pulls right up, and he starts asking me questions about what I was doing and who I was. And he only got the answer because I had somebody with me that night, and she told him that we was delivering newspapers. But
See a narrative response.
Sustained on the narrative response.
Did that end that encounter?
no.
What else happened with this person?
The following day, I went up to his door and delivered a newspaper.
Was he a subscriber?
Nope.
Why did you deliver a newspaper to his
Because
door?
I just wanted him to know that I was delivering newspapers and I'm not stealing packages.
Do you know the name of that person?
Yes. Josh Harris.
And how is it that you know who that is?
Because he followed me around on my route and said that he was a cop and told me to get out of the neighborhood.
How did you come to learn his name?
Further interactions and seeing him on TV.
And Mr. Altheimer, not the easiest name in the world, to be fair. I'm going to go to the incident January 27th, 2021, okay?
Yeah.
Were you working that day?
Yes.
And was anyone with you on your route that day?
No.
Can you please describe the car that you were driving that day?
I would say it's a brown four-door sedan.
You know the make and model?
It's a Geo Prism 1995.
Approximately when did you leave your house that day to go to work?
Well, that day I had to make a special trip to the store to go get some formula, so I left a little bit early.
by formula?
Oh, well, I have kids, so I had,
Formula?
yeah.
So did you tell us when you left the house approximately?
It was about like 10:30.
And where did you go first?
I went to a Safeway.
And what did you do at the Safeway?
I bought 4 cans of formula.
And then when you were done doing that, where did you go next?
Straight to work.
And what does straight to work mean?
I drove down Bridgeport from the Safeway and went straight to 19th, and then drove down 19th to State and went to the warehouse.
And what did you do when you got to the warehouse?
I don't know if the papers were there, but get my papers and get them prepared.
And about how many papers did you pick up that day?
So I had 3 routes at the time, so it was about 400 total, all around.
And after you picked up the papers, where did you go then?
I started down on Jackson, exit number 4, my first house.
And is there a name of that neighborhood?
Like, what do you mean?
Tell you what, can I have you step out of the jury box?
Mhm.
That's all right.
The name in that neighborhood, like, but what is
Okay.
that?
That is State's Exhibit, State's Demonstrative Exhibit 4. Take a moment to look at that. And when you're done, just turn around. Do you recognize that neighborhood? Okay, what is that neighborhood?
This is a section of my route.
Is that the route you went to on the day we're talking about? Okay. Go ahead and have a seat again, please. Prior to January 2021, how long had you been delivering newspapers in that neighborhood? Approximately.
So it was an add-on. So, like, it was like 3 or 4 years.
What do you mean by add-on?
The business started getting smaller and shrinking in numbers, so they downsized and added it to the closest route to it, which was me.
Okay. At an add-on route, basically.
Yeah.
All right. When you got to the neighborhood on January 27th, 2021, to deliver your newspapers, did anything unusual happen?
After a while, yes.
What happened?
I was just casually doing the Vista View neighborhood, and as I was leaving the neighborhood, a white SUV turned onto the block at the same time as I was leaving the neighborhood.
Why did this white SUV, about what time was it at this point?
It was about like 1:40.
In the morning.
Yeah.
Why did this white SUV catch your eye?
Because it kept popping up.
How many times that night did you see the white SUV?
3.
And I should have asked for the judge's permission before you got out of the jury box, but could I have him step out of the jury box again?
No, out of the witness box. No,
Oh, I'm sorry, thank
No
you.
objection?
Come on out.
I hope he's not in the jury box, Charlie.
I want to make sure, so the defense has no objection.
None, thank you.
That's granted.
Okay, picking up that red pen. All right, that is State's Exhibit 4. Can you please show the jury, using the red marker, where you first saw the white SUV? And can you tell us where that is?
This is North 23rd and Vista View.
I'm sorry, could you say that a little bit louder?
North 23rd and Vista View.
Thank you.
And what did you think how many cars are on the road at this hour? And what did you think when you first saw the SUV?
I didn't think nothing of it right here. I wasn't aware just yet.
So what did you do next?
So I just continued on my route. And I took a left on North 23rd and then I took a right on Creed. not excluded, but I circled the block to come back to Vista View. And as I was coming back down Vista View, I got past North 27th where I come out and do half of the area, but I have to go back through. And so I made it to this house. It's probably this one. I stopped right there. Or I didn't stop right here, I pulled into a driveway, and the white SUV was parked on the block, sitting on the curb.
Okay, I'm gonna, so as you were showing the route, the record should reflect you went beneath the map, indicating some streets that aren't on this map, okay? And then, Mr. Altheimer, you just showed us your where you saw the white SUV again. Can you actually use the red marker to draw where you were driving to get there? Okay. And that second location that you marked with an X, can you tell the jury where that is, please?
It's corresponding to where Troyer actually stays. What do you ask?
Okay. I'm going to ask you to speak up, and I'm going to let you know that the jurors can't see those streets. They're too far away. So I'm asking you to identify the location.
This is Vista View Drive.
And what did you think the second time you saw that same SUV?
I got concerned and stuck on the gas a little bit.
And why did you get concerned?
Popped up again, and windows up, dark tinted, couldn't see what it was, where the stops were.
So what did you do at that point?
I continued on my route. I went up, round to Bridge Lane. I went in this cul-de-sac, did my cul-de-sac. I just continued on. And as I continued on, around, and then I got right here. This house right here has the blue tube that we talked about.
I'm sorry,
Huge blue tube, the blue tube.
okay.
Mr. Hines, we're going to have the witness speak up.
That's exact. Yeah, I know it's hard, but one of the reasons I stand back here is to make sure I can hear you, so everyone can hear you. So much louder, please.
Much louder, where do you want me to start?
Well, definitely louder than that. Let's go back to the second house and repeat what you just said.
So I continued down.
Excellent.
Bridge Lane, and then I continued on down to Narrows Drive, or Narrows Lane, and then as I was coming out of this cul-de-sac, I had to stop at this house and deliver to the blue tube, which they have next to the front door. I got out, and as I was walking back from the driveway, the white Tahoe came down over the hill, and I approached it, and that's where we had our first confrontation.
Okay. So as you're driving from the second location that you saw the white Tahoe to the third location that you saw the white Tahoe, were you delivering newspapers during that portion?
Yes. I still continued on my route, and I went inside each of the cul-de-sacs, and I still have two houses before this house.
Okay. And how were you delivering the papers?
These people, I just loaded in the driveway.
Did you ever leave your car at that time?
I only left my car for this house.
Okay, so you're throwing the newspapers out the window, is that correct? Okay, so now we get to this third location, and where exactly was your vehicle?
I was parked directly in front of the driveway.
And where exactly was the white SUV?
He was coming down the hill. He wasn't blocking my car, but he was lined up in the middle of the street.
If I take this down and I put up a white paper, would you feel comfortable drawing those positions?
Was there an answer to that question?
Yes.
Yes. And I'm going to have to mark that. Everything gets marked in court. This is State's Demonstrative Exhibit 16. Okay. At this third location, please draw the position of the vehicles and explain it to the jury.
This is me.
And again, louder. Can you repeat that?
Why? This is the driveway. This is the house. I parked right in front of the driveway. As Troy was coming over the hill, he gave me a little space to live with you.
Okay. And since State's Exhibit 4 is, again, the jury can't see that, where is this location of this third encounter?
It's Narrows PI.
Okay. So what happened there?
As I was walking back from the tube, I had my hands out like this, and I casually approached them. As I approached the SUV, I looked out the window, and the window was slightly down, but it wasn't all the way down. And I was like, oh. And I took a pause because it was one of those moments where you know somebody's face, but you can't put a touch on it. And then so I then proceeded to ask him, why is he following me? Is he a cop? I said no. And is it because I'm black?
And you said the window was down. Which window?
The driver window.
Was this the first time that you laid eyes on the driver that night?
Directly, yes.
Was anyone else in the vehicle other than the driver?
No.
Can the witness be seated?
Oh, yes, please.
Yeah.
Your Honor. How close were you to that white SUV during this conversation?
I wasn't close enough to touch it.
Can you give a little, are you comfortable picking a distance? Or using me as the white SUV?
It was about, you could say the wall was hid, and I just stand back like.
For the record, Your Honor, can we say what that is, the distance?
Are you able to estimate that distance?
What did she say?
She wants you to estimate the distance.
Oh, I don't know how to estimate that. Arm's length.
Okay.
Thank you. Thank you, Your Honor.
Arm's length.
Yeah, it's an audio record, so we
Yeah.
have to come up with more than that.
I understand.
Did the driver during this encounter ever exit his vehicle?
No.
And is the driver in court today?
Yes.
Okay, can you please identify him for the record by pointing at him and telling us what he's wearing?
We stipulate that Sheriff Troyer is the defendant in this case and was in the car, Your Honor.
Stipulation accepted?
Thank you. Yes, Your Honor, accepted. Did the defendant ever exit his vehicle during this conversation?
No.
Did you have anything in your hands during this conversation?
No.
Did you at any time touch the SUV?
No.
Were you able to see if the defendant had anything in his hands during this encounter?
No.
Was your car blocking him in? Could he have left?
Objection is to the continuing leading nature of all these questions, Your Honor.
Sustained.
Was your car blocking his car?
Same objection, same basis.
Same ruling, sustained.
You indicated that you asked the defendant if he was a cop, correct?
Mm-hmm.
Why- I'm just recounting what he said.
Okay.
Why did you ask him that question?
Because if he was a cop, it would have been a different reaction.
Can you explain that, please?
Well, I'd rather stop for a badge than stop for a civilian just stalking me in the neighborhood.
Why did you suspect he was a cop?
Because I know the neighborhood and I've been over there before.
What about being in the neighborhood made you suspect that the defendant might be a cop?
It might not sound like a real thing, but I've been in the neighborhood for not 8 years, but 4 years every day, 7 days a week at one point. So you notice and know a lot of things about the neighborhood.
And what about your observations of the neighborhood made you suspect that this driver might be a cop?
Because he had a
a unmarked SUV with a exempt license plate, the little XMT on it.
And was that the vehicle he was driving that night?
No,
Was this white vehicle, in your mind, associated with the black exempt vehicle?
yes,
How so?
because you see two other white SUVs in the driveway with the unmarked SUV, which is a Tahoe and a GMC.
Why did you ask him if he was following you?
Because he kept popping up and stopping and right where I was.
And how did he respond?
He just talked down to me like I was just lost, like I didn't know where I belonged. He accused me of being a porch pirate. And he just talked to me like I was a lost boy.
Do you recall what else he said to you?
That he had 4 cars coming, and I told him congratulations.
What did you take the term porch pirate to mean?
A guy that is stealing packages.
Did he answer your questions?
No,
Did he tell you why he was following you?
no,
Did he tell you whether or not he was a police officer?
no.
These are all leading,
Sustained.
Did he appear afraid?
objection.
Same ruling, sustained.
What was his tone of voice as he was talking to you?
Calm, normal.
Was that the end of the conversation?
After I said congratulations, yes.
What was the congratulations in response to?
I guess I was just being smart.
What did you do next?
Then I started walking away. As I was walking away, the SUV kind of moved over to the right to, whatever. And then he kind of tried to stop me with his words. And then I just continued into my vehicle, got into my vehicle and stepped on the gas and drove to Deidre Circle.
What did you take the movement of his vehicle to mean?
It kind of alerted me like he was on me, like, he wasn't going to let this go.
You said he tried to verbally keep you from leaving. What to the effect did he say?
Just like, hey, where are you going? Like, stop.
Did you stop?
No.
And why did you leave?
I had no reason to stick around.
And where did you go when you left?
I drove to Deidre Circle.
And as you're driving to Deirdre Circle, did you do anything on the way?
No, there's actively no houses in between that block and Deidre.
What did you do when you got to Deirdre Circle?
So in Deidre Circle, I actually have 2 houses. So I pulled into one of the driveways, and then I backed out and pulled into another driveway. I didn't pull in, actually. I just threw the paper, just quick reaction, try to get up out of there real quick. And then I drove out of Deidre Circle and ran into the SUV coming down the same way.
Why did you want to get out of there real quick?
Because I knew he was coming for me. He pulled a U-turn in the middle of the street,
And where did he pull the U-turn?
right in front of my customer's house.
Was that back at this third location, or was
Yes.
that at Deirdre Circle?
It was at the third location, 2819.
What is this? How large is the SUV compared to your car?
You just like want an example, or
In relation to each other.
a monkey to a gorilla?
Okay, we'll take that. I'm gonna bring back up States 4. And I'm gonna ask the court's permission for you to step back out. Is that okay, Your Honor?
Objection?
No, Your Honor.
Granted.
I'm going to ask you to show us how you got to Deirdre Circle and then where the stop occurred.
So, as we were sitting here, like I said, I walked away from him. I jumped back in my car, I drove straight, and I took the first right, and then I pulled into this cul-de-sac, which is Deirdre Circle. I have two houses in the cul-de-sac. I pulled into one driveway, threw it to the front porch, and then pulled out and backed out, and threw the second one to the driveway, and then as I was leaving Deirdre Circle, I ran into the truck that SUV onto me.
Okay, and how did you run into it?
I was coming out of Deirdre Circle and turned into him as he was coming down North 27th.
Okay, so when that happened, how are these two cars now positioned in relation to each other?
We're parked right in front of each other.
So is it nose to nose?
Can the witness be seated?
Yes, Your Honor, thank you. Did you keep going?
No, then we came to a complete stop. I then took out my phone and started taking pictures of the SUV. Took a picture of the license plate and, just took a picture of the generic SUV of the whole,
And how did you take those photos?
just by my cell phone,
And why did you take those photos?
because he just wasn't giving it up.
No objection.
Mr. Altheimer, I'm showing you states 13. I'll do it one at a time. Actually, and I'll show you states 14 as well.
Mm-hmm.
Do you recognize those photos?
Yes, ma'am.
Okay, what are those?
This is the picture I took of his license plate, and then
Which exhibit is that?
this is 13.
What is 13?
A picture I took of his license plate.
Okay, and what is 14?
A picture I took of the whole vehicle.
Okay, and are those true and accurate photos of the pictures you took?
Yes.
Okay, Your Honor, we'd offer states 13 and 14 into evidence.
No objection as long as we redact the sheriff's license plate number. I believe that's in one of the pictures.
Yeah, it's in both of them.
I don't have an objection to that. We can do that later.
Later or now?
I'm sorry, Your Honor.
Later or now?
Later's fine. Let me just ask my client. Do you want to talk about that? Okay. Later's fine, Your Honor.
So with that understanding, Exhibit 13 and Exhibit 14 are admitted. Counsel, if you could hand those to the clerk so she could mark them as admitted.
Mr. Altheimer, you said you took those photos with your phone. You're talking about a cell phone?
Yes.
Did that cell phone have cell service
No.
at that time? Why not?
Just living in the struggle at the time. Didn't pay my phone bill.
Without cell service, how are you able to make calls?
I don't. Oh, well, the iPhone, I go over to the business and I use the Wi-Fi service if I have an emergency call I want to make.
Were you able to make a call at that location?
No.
At Deirdre Circle, did either you or the defendant ever exit your cars?
Not until police arrived.
Answered my next question. What happened next?
You start hearing little rocks on the ground, and then I look in my rear view and I seen the bright light of another vehicle approaching.
From the time that you were stopped at Deirdre Circle to the time that you saw other vehicles approaching, do you know about how long that was?
It had to be like 7 minutes.
And did you say, again, it's a little hard to, did you say you heard rocks?
Yeah.
Can you tell us what you mean by that?
Like, I don't know. It's just, it was real quiet. And like I said, as I took the pictures and put my phone back down, you just start hearing the gravel. You know something is coming up on you. and it was the police.
And how would gravel be making noise?
Just by the tires.
Tires over gravel?
Yeah.
And when you realize the police are there, what happens now?
Well, I get held at gunpoint. I get questioned and pulled out of my vehicle and frisked, asked questions, treated like a suspect.
When the police approached, what did you do while you were still in the car?
I started ranting, yelling out things, upset.
How are you feeling?
I was afraid and frustrated.
Where were your hands? Do you know?
I had one on the window, and then I had one on the steering wheel, on the top of the steering wheel.
Why were your hands there?
You always keep your hands in plain sight when dealing with the police.
When did you move your hands from those locations?
When they pulled me out of the car. And,
Did the police tell you why they were there?
yes,
Why were they there?
because he's the sheriff.
You testified earlier that when you first saw the defendant, he looked familiar to you and you thought he might be a cop. Is that correct?
Yes.
When did you realize exactly who he was?
After the cop that I was talking to told me.
And is there a reason that he looked familiar? Had you seen him before?
Prior to that, in November, I would come off the freeway and I would see black and green and brown signs, and it had Sheriff Troyer's logo, and then I would see Cynthia, whatever her name is, the runner-up. I would see both of their signs, and I Googled who they were.
Prior to... So, were there photos, were there pictures on the sign?
No, it was just, that's why I Googled it, because I wanted to see who they actually were. But their pictures are not on the sign. It just said, vote for this person for sheriff.
And then you were able to look up what they look like.
Yes.
Prior to the police arriving, did Sheriff Troyer ever get out of his vehicle in your presence?
Prior?
Prior to the police arriving?
No.
You said the police questioned you. What did they want to know?
What I was doing, and what happened.
These events we've all been talking about on this map here.
Uh-huh.
Okay. What city is all of that in?
Tacoma, north end of Tacoma, Washington.
And what county and state is that?
Pierce.
And what state?
Oh, Washington.
Mr. Altheimer, you testified that you had been removed from the car, questioned, detained, treated like a suspect. Could you see where Sheriff Troyer was as all of this was going on?
Yes.
The leading nature of the question, the preamble, Your Honor, and mischaracterized his testimony.
Sustained as to leading.
Could you see where Sheriff Troyer was at this scene after the police arrived?
Yes.
Could you see the interactions he was having with the police?
Yes.
What did you think about those interactions?
Blue's gonna protect blue.
Sorry, Your Honor, objection, relevance.
Not speculation, he formed an opinion based on what he saw. And
Sustained.
Thank you.
Mr. Altheimer, that night, did you believe that the sheriff was going to be held accountable for this?
No.
Leading.
Sustained.
For what? I'll strike that last part, Your Honor, I apologize.
Did you have a conversation with Officer Ventura?
Yes.
Do you know which one Officer Ventura was?
I think he was the driver.
And based on that conversation, did you believe that anything was going to come out of this?
No.
Did the police eventually release you that night?
Yes.
At some point after this event, did you sue Sheriff Troyer in the county?
Yes.
Why?
Why is because I want a fair trial. I want fair justice. I feel like he should be held accountable for wasting the resources and lying.
How much is that lawsuit for?
$5 million.
And how is it that you first connected with an attorney?
Family.
Can you explain that a little more?
Just a family connection.
Okay.
I'm not.
That's all right. That's all right. Is that lawsuit resolved or is it still pending?
Mom, it's pending.
Mr. Altheimer, do you know what a GoFundMe page is?
Yes, ma'am.
Can you explain to the jury, just in case, what a GoFundMe page is?
So a GoFundMe page is something that people really do for you if they care about you enough. They started up a GoFundMe and to help you get what you need.
Did you start a GoFundMe page?
Did I start a GoFundMe? No.
Did somebody else start a GoFundMe page for you?
Yes.
Is that someone you knew prior to this incident?
No.
Thank you.
Oops, I'm sorry. Mr. Altheimer, I'm showing you State's Exhibit 15.
Mm-hmm.
Do you recognize what that's a copy of?
Yes.
What is that?
It was a notice.
More volume on your voice, please.
It was I don't know how to call it, but it was like a flyer.
Is that your handwriting?
No.
Do you know whose handwriting it is?
Yes.
Whose handwriting is it?
Objection, lack of foundation, Your Honor.
Sustained.
Is that your handwriting?
No.
Have you seen those notes before?
Yes.
How is it that you have seen those notes before?
The person that started the GoFundMe, she wanted to get the word out there a little bit more. She felt like it wasn't productive enough, so she asked if I wanted to make flyers.
Who made the flyers?
Carmen.
Who's Carmen?
Carmen V is the lady that started the GoFundMe.
Yeah, we'd asked to admit exhibit 15 and publish it for the jury by having him read it.
May I have voir dire, Your Honor?
Granted.
Thank you. Good morning, Mr. Altheimer. I represent Sheriff Troyer. My name's Ann Bremner.
Mm-hmm.
And this note, where did it go?
I think he still has it.
May I approach, Your Honor?
Granted.
Thank you. Thanks so much. So this note says, search GoFundMe, and it has your name, is that right?
Mm-hmm.
Where were these notes left, if you know,
Where were they left?
or placed, or
Ag-
sent?
So what are you asking me?
What was the purpose of the note?
It was a purpose to bring attention.
And that was a GoFundMe page for you to get a new car, is that right?
Yes.
You told Officer Lawless you had 3 cars, remember that?
Yes.
Okay. And what I'm trying to get at here is, this note was copied and put somewhere. Is that right?
Sure.
Were these put in newspapers?
No.
Were they put in people's newspaper boxes?
No.
Where were they put?
I threw them away.
At the what?
I threw them away.
I still didn't get that.
I threw them away.
Oh, you threw them away.
Is this working?
Yeah, you don't need to lean toward it.
Okay, I'm sorry.
Picking up is fine.
Okay.
But there's one right here.
Mm-hmm.
Is that the only one you didn't throw away?
I mean, they're small little pieces of paper, so I probably didn't grab all of them.
And how did this get to court?
I don't know.
That's all I have, Your Honor. Object on relevance.
No response.
Objection overruled. Exhibit 15 is admitted.
Permission to publish.
There, the exhibit has some relevance. Permission to publish. Defense response to request to publish?
None, Your Honor. Thank you.
Publish means asking you to read it to the jury.
Okay. It says, your newspaper delivery man, Sedrick Altheimer, was harassed by the police for doing his job. They said his car looked homeless, and a homeless man's car. Let's get Sedrick a new car. Search GoFundMe. Thank you, Sedrick Altheimer.
You said you had never met Carmen V. prior to this incident. Is that correct?
No. I mean, yes.
Did the money collected for the GoFundMe page make it to you?
Yes.
And how did it make it to you?
She signed me up as the beneficiary.
And when did that GoFundMe page close, to
I
your
don't-
knowledge?
I was going to say, I don't know when it actively closed, but I know it is closed.
Mr. Altheimer, after the police released you from the scene at Deirdre Circle that night,
Mm-hmm.
did you go home?
No.
Why not?
I had to continue working. I was only on my first route.
About how many papers did you have left to deliver?
I'd say about 200.
Did you finish your route that night?
Yes.
Without revealing any addresses, when you finished your route that night, did you see the white SUV again?
No.
Did you have reason to know, let me put it this, okay. Did you have reason to know where Sheriff Troyer's home was? And again, without revealing an address, please.
Yes.
And how did you know that?
Memory. Memory and knowing my neighborhood.
While on your newspaper route, did you drive past that home?
Yes.
And what did you do?
I threw a newspaper
Where did you throw the newspaper?
just in the driveway.
You had testified earlier that you have sort of a route sheet or something that tells you where you're delivering newspapers to, correct?
Yeah.
Okay. Does Sheriff Troyer take the paper?
No.
And why did you throw a newspaper in his driveway?
Well, like I said, I'm kind of a smart ASS, so I went back to let him know that I was the newspaper delivery person in the neighborhood by throwing a newspaper to his driveway.
And when you threw the newspaper, did you exit your car or did you do that from the car?
I just did it from the car.
Did you say anything?
I might have said, "Here you go,"
And what would "here you go" refer to?
as tossing the paper to the driveway.
Mr. Altheimer, did you ever threaten to kill
No.
the defendant? Did you verbally threaten him in any way?
No.
Meeting.
Overruled.
Did you verbally threaten him in any way?
No.
Did you ever tell him that you were going to take him out or words to that effect?
No.
Did you ever display a weapon or anything that could be perceived as a weapon that night?
No.
Did you ever physically threaten the defendant in any way?
No.
Pass the witness.
It's a good time for the morning recess. So members of the jury, at this time, we'll go ahead and take the morning recess. As I've told you many times, do not discuss this case with anyone and no research about the case as well. So at this time, we'll have you leave the courtroom for recess.
Staff? Oh, okay, I'm with you. That's what I wanted, yeah. But these are in. Not all. Fine. Do we want to use, we don't want to use church closet, do we? No. And then,
The jury has left the courtroom. Thank you. You may all be seated. Anything from the state before recess?
No, Your Honor, thank you.
Anything from the defense?
no, Your Honor, thank you.
Right. Thank you. The court will be at recess. We will re-adjourn at 10:45, so about 15 minutes from now.
Thank you, Your Honor.
So you can
Thank you.
set off now.
Thank you.
Court's at recess.
Okay, it's all good.
Testing 1, 2, 3. Testing sound on live stream. Video is a go.
Yeah, that's fine. No, I don't want to.
Testing 1, 2, 3. Testing live stream sound. All rise. District Court is back in session.
Thank you, please be seated. Ms. Bremner.
Thank you, Your Honor. Just briefly, we had visited this issue, of course, pre-trial, the motions limine and orders in limine. But we do believe that with respect to the fact that there was a warrant, as I understand it, out at that time, that there, from his department, through the Department of Corrections, and his license was suspended, that those items should come in when it comes to animus toward the police and specifically the sheriff when he's being stopped. Well, he wasn't actually stopped, he confronted the sheriff, but I think that that should come in terms of how he acted in our defense, that there was a threat and it wasn't a false report.
You know, the stretch between him driving with a suspended license, being on DOC supervision, and the warrant has nothing to do with animus towards the police. They're just trying to backdoor in this irrelevant and highly prejudicial information. There's simply no link between those two things. And if there were a link, the English Channel would be between them. That is simply such a stretch to try to get in irrelevant and highly prejudicial information. Nothing has changed in the testimony today since the court previously ruled properly to exclude that.
Your Honor, just briefly, it would go to his interest in not having contact with the police. And because what he just put in front of this jury is that nothing happened. I mean, basically, this was a non-event. And there, I'm still speaking. And so he's basically saying that, you know, he was being followed, and then, you know, he acted appropriately, and there was really a non-event. Well, the fact is, he didn't want to be detained by the sheriff. He didn't want to have contact with the police. When you have a warrant, you can go to jail. You know, we have a suspended license, and you're driving in the neighborhood, that's a crime. And those weren't pursued. He was let go, but it goes exactly to our theory that he didn't want to be detained, and that he made the comment that he did to the sheriff. And I have one other matter. Apparently the defendant's mother, Mr. Altheimer's mother has been in court all morning, or part of the morning. She was on the witness list, and I would just indicate in at least one interview with the Attorney General with Mr. Altheimer, he said that he called his mother. He asked if he spoke with anyone else on his route that night. Altheimer said he claimed his mother and told her what happened. So she should not have been in the courtroom. She's a potential witness. And we've dealt with this at length with our client's wife, who's not been able to be here because she's a potential witness. So she should have been excluded, Your Honor, from the courtroom. And the state said they just realized that she was here. So she's been here this morning. And that's all I have.
Steve.
Your Honor, in a reverse order, I've never met Mr. Altheimer's mother. I was literally in the women's room making small talk with the woman in front of me, and that's when she identified herself as the mother. We had told her, do not watch this trial, do not watch the live stream. I did not know she was here. She is not a witness for us. She is a witness for them. I know we cross-endorsed. I asked them, I notified them right away that the mother was here and that I had just learned that in the ladies' room, and asked, are you intending to call the mother? And they said no. And I said, well, in the interest of safety, do you want her to leave? And they said yes, and I went and talked to her, and she has left. In terms of not wanting to have contact with the police, of course, he doesn't want to have contact with the police, but he did not contact the police. Sheriff Troyer contacted him, called in a call, and then the police came. And I just don't see the link when he's not the one who initiated the contact. And then he left.
Defense.
Your Honor, he did initiate the contact, and I think that this is relevant evidence. As to the mother of the claimed victim, we're not going to be able to call her now that she's been in court, right? We'll discuss it. But as to the former issue, clearly, in a criminal case where Sheriff Troyer is charged with false reporting for saying that he was threatened by somebody, if we can't get in the fact that this person had a reason to get away, a reason to threaten, I think that's fundamentally unfair, and so we're asking that those, and I'll keep it finite, I'll keep it brief, but I think it's relevant. Thank you.
Oh, State, I'm sorry.
Nothing has changed since the court's prior ruling.
Yeah, with respect to the second issue about a potential witness being in the courtroom, is it, well, I mean, this may be premature, and if it is, defense, please let me know. Is it anticipated that the defense would want to call this individual, or that this individual at this point could be released anyway? And not because the person may have been in the courtroom, but just that that's part of the defense strategy.
Do you want to let her go? Unfortunately, Your Honor, we're going to have to let her go as a witness, even though he
Why do you
called
say
her
that?
that night.
Just because she was here doesn't mean you can't call her.
All right.
It may be an issue with respect to what testimony
Right.
may come out, but that, you're not, I want to make clear, the court is not prohibiting the defense from calling that witness if you think that's something that you should do on behalf of Mr. Troyer.
I guess we're going to have to see at the end of the testimony of this witness, Your Honor, because he did say he called his mother and explained to her, told her what happened.
So to be clear, the defense, if you choose to call this person, the court's going to allow that to occur with respect of a potential violation of a motion in limine, that we should address that and the extent of any questioning that may occur with respect to that witness, but that's a different issue than keeping that person off the stand. I'm not going to do that. If you want to call her, you're going to be able to call her.
Thank you, Your Honor. That's all I have.
All right, so that's with respect to the second issue that was brought. With respect to the first issue, the court made quite a lengthy ruling during its motion in limine on these topics with respect to a suspended driver's license and an active warrant that may have been outstanding at the time of this incident. And the court found, in looking at my notes, that this was irrelevant, that if it was relevant, it would go to improper character evidence under ER 404A and B, and then did the balancing under ER 403 and found that because the evidence was of such minimal relevance, if it was relevant, to with respect to whether a threat would be made. And the court agrees with what the state had said today. These suspended driver's license and or a warrant, those facts are a long stretch with why this person may or may not have threatened the defendant. The logic just doesn't appear to the court why those two facts would be something that would lead to say, well, then he must have threatened the defendant. And so it has low probative value, and so under ER 403, the prejudicial effect to the state is substantially outweighs the probative value. But I made that, the court's endorsed or adopting its record that it made during the motions in limine, as well as the comments I made today. So the defense motion to permit cross-examination concerning Mr. Altheimer's driver's license status at the time of the incident and concerning whether Mr. Altheimer had an active warrant at the time of the incident, both those motions are denied. The defense that evidence is excluded in the case.
Thank you, Your Honor. And just for the record, the purpose we would be offering the evidence for would be his motive to get away from Sheriff Troyer, to not be detained in any way for those potential offenses or on the warrant, or the offense or on the warrant, and therefore his motive to basically make the sheriff go away, threaten him, say, I'll take you out. And by the way, he confronted the sheriff, not vice versa. So I think that it would go to all of those arguments on behalf of my client. Thank you.
Those arguments were made during the motions in limine, and the court rejected them then and rejects them now.
Thank you. And I have nothing further.
Anything from this,
No, Your Honor.
I was looking at my notes here during the break, and the defense had brought up that there may be some issues you wanted to raise after direct but cross, and I just want to make sure that I haven't forgotten something with some rulings. I think I just said, let's deal with it now, and so I want to make sure that if there's something on that topic, we raise it now.
Yeah, I don't think the court ever forgets about anything. But no, that's all we had. That was referencing what we just addressed, so I thank you for that.
Thank you.
And we're ready.
You would, the clerk would please bring the jury back in the court.
Would you like the witness up there now, Your Honor? or
That's up to
after?
counsel's choice.
That's fine.
Your witness, do you want him up there now?
I just said it's fine.
Mr. Altheimer, you can come on back up here and have a seat if you prefer.
Yes, please.
It's fine. A little bit.
The jury may be brought back into the courtroom.
Your Honor, it's all right if I come up here?
Of course.
There's so much stuff.
Do you want the podium, or is that fine?
Actually, I would, Your Honor. Thank you. I didn't even think about that.
Let the jury come in and then we'll
Okay,
get staff
thank
to
you.
help you with
Okay.
that. The jury is entering the courtroom. Thank you. Everyone may be seated. And we are getting the podium.
Okay, thank you. Should I proceed now, Your Honor, or wait for that?
It's just right out the,
Oh, good, thank
we're
you.
right there. So.
Yeah, I see you. I appreciate it. Thank you so much. Yeah, that's perfect. Thanks. Appreciate it, Your Honor. Thank you.
The witness, you are still under oath. You understand that?
Yes.
Thank you.
Okay.
Ms. Bremner,
Thank you, Your Honor.
cross-examination.
Thank you. Mr. Altheimer, what you just testified to in front of this jury sounds almost like a non-event. Is that fair to say?
No.
You weren't arrested, is that right?
Yes.
You weren't prosecuted, is that right?
No.
There was no weapon that the sheriff had, is that right?
No.
He did have a weapon?
Oh. No.
Okay.
No. Yeah. I said no.
And it's fair to say that you walked from your car to his car, not vice versa, isn't that right?
Sure. Yes.
Okay. And you went up to the window of his car, isn't that right?
Yes.
And you were agitated, isn't that right?
No.
When you went up to the window, you spoke to him, is that right?
Yeah.
And what you said, I think you said in the Joyce Taylor interview too with King 5 is, you said three things. The first one is, why are you following me? The second one is, are you a cop? And then the third one was, is it because I'm black?
Yes.
And then you said that he, at that point, called for extra police units?
He wasn't holding a phone to his ear, but that's what he said.
He was or he wasn't holding a phone to his ear?
He wasn't.
Wasn't. He said he was going to call the police,
Yes.
based upon what you said that we've just talked about, and nothing else, right?
Yes.
And then once he said he was going to call the police, did you go back to your car?
Yes.
And you just sat in your car?
No.
What, you drove or not?
I drove off and continued down the street.
is it your testimony based upon the incident you've described that he asked for a massive response of police units?
Objection outside the scope of this witness's knowledge.
Overruled. He may answer if he's able.
I have no recall.
You have no clue?
I had no recall.
You have no recall?
Yes.
But you hadn't done anything, per your testimony, to warrant any police response. Is that what you're saying?
Besides being black,
And the 10 other times you were followed, do you know why you were followed?
you said 10 other times?
In the other times you were followed,
Oh.
do you know why you were followed?
Because I am black.
Every time.
hmm
And I want to be clear on those times. Were those times by the police?
Oh, no, these are civilians.
So the civilians that followed you, how many were there?
2.
And they both followed you because you were black, is that what you said?
Mhm.
And how many other times did the police follow you?
Just whenever they show up in the neighborhood.
More than 5?
Yeah.
More than 10?
Hearsay.
I'm sorry?
Hearsay.
Okay. And are you saying that all of those times it was because of your race?
And suspicious looking.
Pretty dark at the time of your route in that neighborhood, isn't that right?
Depending on what street you're on.
Okay. How about on Deidre Circle?
Yeah, it's dark.
Okay. And how about where you encountered the sheriff?
Dark.
Pardon?
Dark.
We saw the pictures of the, at least of the back, of the front of his car, of his license. And it looked pretty dark out, right?
Yes.
Isn't it true that you could not tell his race when you were being followed?
No.
You could see his race.
When he first passed me, I was able to see that it was a white male.
And do you know whether or not, only if you know, he could see your race 2 in the morning?
I can't answer for him.
You talked about some folks in terms of following you. There was Josh Harris that you talked about. Do you remember
Yes.
that?
Yes.
And he followed you once or more?
It was once.
And why did he follow you, in your opinion?
Because I look suspicious.
Was he someone on your route?
He lives on my route.
Did you ever deliver papers to him?
After he accused me of being suspicious.
And when you say he accused you of being suspicious, what did he say?
He, I don't know exactly or what he said at the time of the incident, but he wanted to know what I was doing.
What were you doing when he asked you that?
Delivering newspapers.
Did you then go to his home at 3 in the morning after that?
Yes.
And did you bang on his door at 3 in the morning?
I didn't bang. I knocked.
You knocked on his door at 3 in the morning?
Yeah.
And did you yell at that time too?
No.
What did you say as you knocked on the door at Josh Harris's house?
I didn't say anything.
And did he come to the door?
Yes.
Do you know if other members of his family were awakened by your hitting the door at 3 in the morning or knocking on the door at 3 in the morning?
Well, I think the wife came to the door.
The wife came to the door?
Yeah.
And did you point a newspaper at her or him, making it look like there was a gun?
No.
Are you sure about that?
Yes.
What about, did you also go to his workplace? Actually, let me back up. Did you go to his house twice at 2 or 3 in the morning and knock on the door?
It was once.
And then, so if he said it was twice, would he be wrong?
Yes.
There's also, there was somebody else that, Dan Bassett, where you showed up at his house in the middle of the night or early morning. Do you remember that?
I don't know who that is.
Have you shown up at any of your other customers' houses at 2 or 3 or any time overnight at their front door and knocked on their door?
No.
Why did you go to Rob Harris's house at 2 or 3 in the morning and knock on his door? What were you trying to accomplish?
Who's Rob Harris?
The one that you talked about harassing you just now.
Oh, John Harris.
Or Josh, excuse me, you're right.
Josh Harris. Sorry.
Right.
To just let him know I was a newspaper carrier, and I asked him if he wanted to subscribe to get in the newspaper.
Okay, and what did he say?
He said no.
So, just so we're clear, if he or his wife say that you use a newspaper like a gun in a threatening way at 2 or 3 in the morning after knocking on their door, and they felt threatened, did that happen?
Objection, alleged fact, not in evidence, and asked and answered.
Overruled concerning asked and answered. Overruled concerning alleged fact. It was overruled.
Thank you, Your Honor.
What was that?
Answer if you can.
So can you re-ask the question?
Sure. If Josh Harris and/or his wife were to say, and then testify here potentially, that you came to their door at 2 or 3 in the morning, knocked on the door, and
And Your Honor, may I be heard outside the jury's presence?
Your Honor, I'm just
Let's
asking.
ask the question first.
Thank you.
Well, it pertains to this question.
Your Honor, I've already asked the question. I don't want
Yes,
to.
members of the jury, at this time, I'll have you go back in the jury room, do not discuss the case with anyone, and no reason.
Okay. Okay.
The jury has left the courtroom. Thank you. Everyone may be seated.
Your Honor, I wanted to correct one thing in terms of what I'm asking. The newspaper part was not at the door.
Oh, if you could turn your microphones off.
Oh, that's got what?
You want them off? Did you say?
It's on now.
Oh, with the lapel mic.
Yes.
Is there any?
Well, there hasn't been, so.
Right, no, that's fine. Sorry, thank you. Ms. Brett.
Thank you, Your Honor. I just wanted to correct what I'll be intending to ask, Your Honor, and maybe this is the point that's going to be raised, that the pointing of the newspaper wasn't at the door, but at a separate incident. Is that right? No, the incident that preceded coming to the door, so I want to clarify that. He pointed the newspaper like a weapon in the incident that he's described as being harassing before the incident at the door. So that's the question. Before he came to the door.
Oh, but the incident that the witnesses talked about,
Yes, exactly.
so it was before, say that again.
Yeah, sorry, Your Honor, there's a lot, it's confusing. So there was the incident where he claimed he was being harassed, where the witness claimed he was being harassed by Mr. Harris, or followed. And then in that incident, there was the use of a newspaper in some manner that could be looked as if he was trying to show a weapon. After that would be the time that Mr. Harris would testify, am I right? That he came, that Mr. Sedrick or Mr. Altheimer came to his door in the middle of the night, which would have been 2 to 3 in the morning.
Oh, I see. So this is not at the Harris residence that
Yep.
you're talking about, the first incident.
That's right, and I apologize, Your Honor. We've got a lot of things like this, but that is correct, is that right? Thank you. No, and I know that Mr. Altheimer is here for the conversation. I don't object to it, but I could have asked for him to leave. I'm not doing that.
That's true. You could.
I know, but I don't want to take more time, Your Honor, so I'm happy to proceed.
All right.
All right.
State.
And the state's response and concern is this. First of all, the newspaper incident they're talking about, Mr. Harris was interviewed by the Attorney General's office. I included his statements in our motions in limine, and what Mr. Harris told the Attorney General's office is that Mr. Altheimer had a newspaper tucked under his sweatshirt. Never mentioned a weapon. It was a newspaper under the sweatshirt, and Mr. Harris's opinion of, oh, he was acting like that was a gun, that's entirely irrelevant. But the bigger point of my objection is this. They need to ask this witness what happened without inserting alleged facts into the question. And here's why. Mr. Harris, the court indicated, might be allowed as an impeachment witness. and the court will have to make that determination after hearing from Mr. Altheimer. But Mr. Harris, I will represent, comes with a lot of baggage. So if they want to call Mr. Harris, the state will be able to cross-examine him. But they're not doing that. They're trying to get in Mr. Harris's statements that are not in evidence without calling Mr. Harris. They're going to need to ask this witness what happened. The court's going to then need to be able to make a decision on whether or not Mr. Harris will be allowed as an impeachment witness, at which point the state will be able to cross-examine Mr. Harris. But they can't just say, well, if Mr. Harris said this, if Mr. Harris said that, that's what they can't do. Because I can't cross-examine her statement to the witness.
Your Honor, how can we know how to impeach him if we can't ask the question? I haven't heard any rules cited by counsel to say that this is not proper impeachment of a witness. And so I'm not following why there would be any kind of a claim that I have to bring in that witness even. Finally, on direct examination, this was elicited. So I'm simply inquiring and following up on that direct examination.
Well, with respect to what the state just raised, the court agrees with the state. It's certainly, and the court has authorized, you can ask, did you point a weapon, did you make the paper look, all those leading questions are
Right.
completely fine. Saying that another witness who hasn't testified said this and therefore you're responding to the truthfulness of that witness, that's improper.
That's fine, Your Honor. I mean, I can confine it in terms of whether he did X, Y, and Z without saying the other witness would say X, Y, and Z.
And that's appropriate. I don't have an objection to that.
Well, no, defense is right about that, yeah.
Right, not-
Well,
I
certainly, the door's been opened, well, the court's made rulings with respect to Mr. Harris and some of this conversation, and the defense certainly has the ability to get into that. Asking the witness leading questions as to what occurred or didn't occur is fine. Just, there's no need, there should not be a mention of what another witness said and asking him to respond to the truthfulness of that witness.
I agree, Your Honor.
That's not how impeachment would be potentially raised.
Agree and understood, Your Honor, and we're ready.
Oh,
Okay.
okay, anything else?
No, do we have anything else? No, thank you, Your Honor.
Nothing else from the state, thank you, Your Honor.
Thank you. Bring the jury back in.
Okay.
State's objection is sustained, given further information with the jury not being present.
That's right, okay. What school?
I do want to have for counsel, too, that if you feel it's appropriate to have the jury removed so we can further explore issues, say so. I'm opposed to sidebars, but that doesn't mean I don't want you to be able to make a record. And so if that needs to be done, that's fine. The jury is coming back into the courtroom.
Thank you, Your Honor.
Thank you. Everyone may be seated. The state's objection is sustained.
Thank you, Your Honor. Going back to Mr. Harris, Josh Harris,
Yes.
isn't it true that during at least one encounter with him, that you put a sweater underneath, or excuse me, a newspaper underneath your sweater or a sweatshirt or something, and used it like you were indicating you were pointing a gun?
No.
After that alleged incident that you talked about where you felt he was following you, that you talked about with the lawyers for the state, that's when you went to his front door, right?
I don't know what you just asked me. I'm like,
Okay. After the incident you just talked about,
Uh-huh.
you went to his front door after that incident, isn't that right?
Yes.
Okay. And just so I'm clear, it's your testimony that when you went to his house at 2 or 3 in the morning, knocking on the door, you just were going to say, thank you for being a subscriber. Is that right?
No. I asked him if he wanted to subscribe.
Oh, okay. And at that hour, did he say yes?
Oh, he said no.
Okay. Dan Bassett, you remember Dan Bassett? He's the principal at Wilson High School.
No.
Isn't it true that you went, and he's on your route or area, isn't it true that you went to his house in the middle of the night and started knocking on the door?
I don't even know who that is.
Was there anybody besides Mr. Harris where you went to their front door at 2 or 3 in the morning, or after midnight?
Troyer.
And that would be the night of our incident, early morning of our incident, isn't
Yes.
it, right?
Yes.
Because after you had this incident with the sheriff
Mhm.
at 2 in the morning, you went back to the sheriff's house at 4 in the morning, right?
I don't know what time it was, but sure.
Okay, but it was after 2.
Yeah. I mean, yeah.
And you knew where he lived, right?
Yes.
Okay. And then you went to his house, and he didn't subscribe to any of the newspapers that you carry, isn't that right?
Yes.
And isn't it true that you revved your engine and started yelling up at the sheriff's house around 4 in the morning, a couple hours after this incident?
No.
Your testimony is you just drove there and threw a newspaper?
Yes.
Nothing else?
Nothing else.
And did you go again after that?
No.
Sheriff Troyer's house?
No.
So never again, you never went to his house again, right?
No.
And can you explain then why there is a TNT news, well now it's just the Tribune, newspaper, oh, I'm sorry. A newspaper dated January 28th, 2021, that was at Sheriff Troyer's house.
We established that.
Was that the one at 4 in the morning?
Yes.
Okay. Can I get that mark, please? And then there was nothing after that?
Hmm?
And you're sure about that?
Yes.
What's the exhibit number on that?
C.
Thanks so much. Can I approach the witness, Your Honor?
Granted.
Mr. Altheimer, I'm showing you what's been marked exhibit number 6. Can you tell us what this is? Just tell us what it is before we show it.
Yeah, for the record, this is exhibit C.
Oh, see, thank you. I need my glasses at all times.
This is a Bag News Tribune by Sedrick Altheimer.
It's what? I'm sorry.
It's a Bag News Tribune by Sedrick Altheimer.
Okay. How can you tell it's from you?
I just know how I roll my papers and do my job.
Right. And was that the paper potentially that was left at Sheriff Troyer's house after our incident?
Sure.
We offer Exhibit C, Your Honor.
No objection.
Exhibit C is admitted. Hand that to the clerk so she can mark it, please.
Thank you. Thank you. Do you know if Sheriff Troyer ever took the newspaper while you were the carrier there in the neighborhood?
No.
Just of you? Are you saying he never did, or that you don't know?
Oh, I don't know.
You don't know, thank you. And do you know, or do you remember a Marilyn Guzman in the neighborhood?
No.
You testified earlier that you don't deliver in that area anymore. If I could approach the diagram, Your Honor?
Granted.
And especially down here along, if you
No,
want
I
to sit down
don't
with me
think
for a
that
minute.
was his testimony.
I object to speaking objections.
That's a fact not in evidence. He didn't testify that he's no.
Sustained. Sustained.
Mine sustained, Your Honor, or counsel's?
The state's objection sustained.
Thank you, let me ask you
That's a,
something from mine.
please.
Thank you. If I could ask Mr. Altheimer just to step with me.
Or state, rather?
Oh, no objection to him.
Granted.
You can
Thank you.
leave off.
Just quickly, I wanted to ask you, can you show us, and I'll get out of the way of yours, can you show us on here where Sheriff Troyer's house is? About, you don't need the exact house? Okay, so you've indicated up on Vista View toward the top of the diagram.
Yes, ma'am.
Okay, do you still deliver along this street, Vista View, within, let's say, 5 houses of each way of the sheriff?
At the time of the incident?
Right.
Yes.
How about now?
No.
Thank you. You resume your seat. And you may be aware, you may not be aware, that there's no one there subscribing on that street. Do you know one way or the other if anyone still subscribes to a physical newspaper on that street?
Not actively, no.
Okay. Exhibit number B was something that has been admitted, and this was from your boss, Mr. Steiner. And if I could approach the witness again, Your Honor? Has it been actually admitted or just identified?
I'll show Exhibit A has been admitted.
I'm gonna
Exhibit B has been admitted.
I'm sorry, Your Honor?
I don't show that it's been admitted
Okay.
or even offered for admission. Have the clerk check on that on Exhibit B?
Okay. Okay. I'd like to show it just to the witness, Your Honor, and then we'll have to tie it up later for if it's going to be offered.
Give me approach.
Thank you. Exhibit B is I don't know if you've ever seen this before,
Yeah.
but it's a list of complaints against you in your various routes.
Mm-hmm.
And it has about 4,000 complaints, doesn't it?
Mm-hmm.
And would that average about 5 complaints a day for the 2 years that are contained in that list?
Object to the characterization, that was his entire work history of, I think, 8 years.
No, it was 2 years, Your Honor.
Sustained, the witness can identify that if you.
What dates does that cover?
The first date is 11/21, and then the last date is 11/24/2022.
Okay. So 2 years, 2 to 3? Not your whole time that you've delivered newspapers, right?
Mm-hmm.
How many years have you delivered newspapers?
About 8 or 9 years.
Thank you. May I approach the witness again, Your Honor?
Go ahead.
Thank you. And just so we're clear, this history is for how many years from what you've seen?
The 21 to 22.
Okay, so 2 years. And I guess we could do the math, but it's 4,000. You remember, you didn't know Miss Guzman, right?
Mm-mm.
You never, she complained about suspicious activity by you in the neighborhood, looking in cars or trying car doors?
No.
Did
Not in evidence.
Sustained.
Have you had any other complaints about suspicious behavior
No.
that you know of? Now, what you showed on the route for the jury of where the incident occurred, do you know that your route is significantly different than what Sheriff Troyer said was the route that was traveled by the two of you? If you know.
I know that he circled the block.
That what you trace as a route is not what he traces as a route. He traces about 3 blocks, 3.5.
Objection, fact not in evidence.
Sustained.
How many blocks do you show that you traveled?
How many blocks do I pass? How many blocks do I?
How many blocks did you travel while he was following you?
It wasn't. I don't know how to answer that.
Okay. You've made a claim for damages, is that right?
Yes.
And you say in the claim for damages, you're claiming, and I'm quoting, no less than $5 million. Is that right?
Yes.
I want to ask you about the complaint that you filed and then show the claim to the jury. But let me just go through the complaint. Did you file in federal court, do you know?
No, I do not know.
Okay. And you have a lawyer,
Yes.
right? And you filed a lawsuit for for unreasonable search and seizure, right?
Yes.
Objection,
Or-
lack of foundation.
Sustained.
I'm sorry, Your Honor, this is his complaint.
You're not testifying.
That's true, Your Honor, but I can ask, what did you file a lawsuit for?
I don't recall.
You don't recall?
Yeah.
Okay. But you did file a claim for no less than $5 million, is that right?
Mm-hmm.
Do you recall at all claiming that you were maliciously prosecuted in this
Same
case?
objection.
I can. No, I'm sorry, I'm not understanding the court's rulings. He's filed a lawsuit with certain claims. I guess I can show it to him?
You can proceed how you want.
I know.
That objection is sustained.
All right, I'll come back to it, Your Honor. Can I get this one?
This is being marked as Exhibit D.
I'm showing this to counsel, Your Honor. This is just from your file. From here. May I approach the witness, Your Honor?
Granted.
I'm showing you what's been marked Exhibit D. Are these pictures that you took that night or early morning and gave to the Attorney General's office?
Yes.
And did they accurately show how dark it was?
Yes.
And what's seen in the picture?
The first one, this little small one, is a picture of me taking a picture out my back window to show that the cop's presence. And then I took another picture as I was coming back off the block. I took another picture of the cop just sitting there, just to have video or recognition of what happened.
Does that accurately show what you saw when you took that picture?
Yes.
We operate, Your Honor.
No objection from the state.
Exhibit D is admitted.
Thank you. Request,
If you could hand that to the clerk so she can mark it first,
thank
please.
you. And request permission to publish.
State.
No objection to that either.
Thank you.
Request to publish granted.
Thank you, Your Honor. This is the top here. I got it. All right. So, the top picture, is that like a light bar in a police car in the dark?
Yes.
And then the second one, is that the same picture or a different one?
It's
Go ahead.
it's a different picture. Just when I actually turned back around and finished my house.
But does that show how dark it was?
Yeah.
At the time?
Yeah.
Do you remember any streetlights at all?
There's a couple here and there.
You said that, have you ever said that you were held at gunpoint?
Yes.
Okay. Where'd you say that?
That's a good question. I don't know.
And the officers in this case, we had indications, if the officers said that they either had guns at low ready or at the highest chest level. Let me ask you this way. When you talk about pointing the gun, you mean basically pointing a gun at you like I'm doing, right?
Yes.
Okay. Is that what happened?
I don't know indirectly. I was facing the back of them, or they was behind me.
So you're saying,
If I turned around, the officer yelled at me and told me to stop moving.
did you see a gun pointing at you when you turned
He
around?
didn't give me a chance to look at him.
So when you said you had guns pointing at you, you didn't see that, did you?
No.
And you said, I think you've also said publicly, that you thought you were going to die, right?
Yes.
Okay, and that was because they had guns pointed at you, as
Yes.
you've said, correct?
Yes.
Okay. And that you also said, I almost died. Remember saying that?
Yeah.
And that was again because, as you've said before, you had guns pointed at you, correct? The confrontation, you have now said that the sheriff confronted you first? Did I hear that correctly?
He stalked me first.
Okay. He stopped.
Stalk.
Oh, stalked you first?
Yes.
Okay, but in terms of confrontation face to face,
Yes.
you confronted him first, didn't you?
I asked him questions. Yes.
You physically came up to him first, didn't you? At his car.
Yes.
At that time, how would he have known that you were a newspaper carrier?
I don't know.
There was no sign on your car, right?
Mm-mm.
And you had, we've already talked about the fact that it was very dark out,
Mhm.
right? And so when you came up to him at the car, You didn't say, I'm just delivering newspapers, did you?
No.
Okay. And when you came up to him with the car, you didn't say, I'm a newspaper carrier, did you?
No.
In fact, you never told the sheriff that you were a newspaper carrier, did
No.
you? Okay. He found that out through other people later, isn't that right?
Mm-hmm.
You talked about someone taking a U-turn, and you said the sheriff took a U-turn, but in fact, you're the one that took a U-turn, isn't that right?
No.
And so you're basically saying that the sheriff made a U-turn, and then you went to confront him, correct?
Huh?
He made a U-turn, but then you're the one that got out of your car and went to his car.
When we say misleading, you're trying to mix it up now.
Oh, I don't want to do that. I mean, I'm just here for the truth.
Yeah, I am too.
Okay.
So, as I was delivering a paper, I walked to his vehicle. As he was coming down the hill, he was pulling up on me. That's when I approached him and asked him the 3 questions. Then after we had our short discussion about me being a porch pirate and his wife is black, I hopped back in my vehicle and told him congratulations on my way to my vehicle.
You've also said that this is an all-white neighborhood, didn't you?
Yeah, it's considered, yeah.
And that's just not true, is it?
I don't know how you want to look at it.
Well, do you know that Sheriff Troyer's family and household's not an all-white household?
I don't know everybody in this household.
So you basically said that he said his wife was black, but you've learned since that she isn't, right?
I haven't learned anything.
You said you just said congratulations, right?
Yes,
And that's when he called for it back up, correct?
yes.
Did he call on his phone or on a radio, do you know?
Do not know.
Isn't it true that he never made any racially discriminatory comments to you at all?
No. I mean, other than calling me a porch pirate,
Did he mention your race, ever?
no,
Did he ever make any racially disparaging comments to you?
no,
Or in your presence?
no.
Did he ever show any kind of weapons? Do you know if he had any?
No.
He was in plain clothes, wasn't he?
I only got to see his jacket.
I'm going to show you part of the Ventura body cam video, but I wanted to ask you a little bit about that. On the video, at any point do you say that you knew he was the sheriff?
Yes.
And so when we watched it here and you said, I know he's the sheriff, you knew he was the sheriff, right?
Not indirectly, but yes.
And you said that on the tape, and the tape showed what you said, right?
Yes.
Okay. And you were pretty agitated on that tape, right?
If that's what you want to say, yes.
You were mad on that tape.
No.
Okay. Were you acting any differently than you're acting right now?
Yes.
Okay, can we show that?
This is exhibit.
It's the Ventura's body cam. It's a state's exhibit.
I show that was exhibit 2.
2, that's right, thank you.
And exhibit 2 has been.
This is so weird doing this stuff. Thank you. And with permission of the court, I'd like to show that part of the exhibit to the, published to the jury.
Steve?
No objection.
Granted. So, Altheimer, are you able to see items that are put on this?
Yeah, that first one popped up, yes.
If you're not, please.
Okay.
I'm sorry,
I
Honor.
just want to make sure you can see the
I know, it's funny the way the witness stand is. Thank you. Can you see okay, Your Honor?
Yes.
Okay. Thank you.
I'm just showing this. I have it.
And while she's pulling that up, you took some pictures that we just looked at, but you also were filming from your car, weren't you, sir?
No, I didn't take a video that night.
Okay. So have you told anyone that you did take a video that night?
No.
No? I'm not touching anything.
Okay.
Did you start right at the beginning?
Mhm.
It was published on it, and I'm going to ask my paralegal where to stop it, but since it's in evidence.
Okay.
And so, sir, I'm showing you the body cam from Officer Ventura, and just want to ask you if you remember how you acted that night. I'm going to ask about a few things you said, okay?
Okay.
Thank you. The sound comes from the camera.
Mhm.
Give me 1 second.
Quiet up first.
Give me 1 second.
Of course, I- Are you ready?
Mhm.
35, boy, William, boy, 587.
Can you turn it up?
Hey, keep your hands where you can see them. Hands on the steering wheel.
Is that what you're coming over here for?
Yeah, that's why we're coming over here, okay?
I'm suspicious, huh?
No, because she called saying
I
that...
don't care what he calls
Okay.
for. He's following me.
Okay, we'll figure
Don't talk
everything
to him.
Start
We
it
will
You
again,
should figure
so
out nothing. I am working.
We
About
will
a year
figure
I
over
am
here.
working.
And the jury, of course. Why don't we just do one of the mics?
Oh, I did.
No. Isn't this going amplified? We'll just have a moment, Your Honor.
You could also use counsel's mic that's on your,
This?
well, the mic on the desk.
It should be okay.
Okay, thank you.
Tap that to make sure that it's working.
Okay, maybe we should just try it again.
boy, William, boy, 587. Hey, keep your hands where you can see them. Hands on the steering wheel.
Is that what you're coming over here for?
Yeah, that's why we're coming over here, okay?
I'm suspicious.
Thank you.
No, because she called saying
I
that...
don't care what he calls
Okay.
for. He's following.
Mhm. Okay, there we go.
Boy, William, boy, 5872. Hey, keep your hands where you can see them. Hands on the steering wheel.
Is that what you're coming over here for?
Yeah, that's why we're coming over here, okay?
I'm suspicious, huh?
No, because she called saying
I
that...
don't care what he calls
Okay.
for. He's following me.
Okay, we'll figure
Don't talk
everything
to him. I
We
don't
will...
need you to figure out nothing. I am working.
We will figure
I
everything...
am working.
Okay.
I'm a black male in a white neighborhood, and I'm working.
That has nothing to do with that.
Yeah, it
okay?
does.
No.
He's following me.
Okay.
The fuck?
He's getting out of the way, okay?
Okay, he's still following me.
We will figure that out. If...
Yeah, get the fuck away from me. I don't care how many cops show up. He's following me. Fuck, I don't give a fuck. I know he's a fucking cop. The fuck? You need how many cops for a fucking newspaper carrier? Oh, you guys are some badasses. I swear to God, you guys are badasses.
Okay.
Stop
Just-
reaching for stuff, dude. I'm not reaching for shit. And don't keep your hands on the steering wheel. My hands haven't moved off the steering wheel.
Okay, can I explain it?
No, I don't need nothing to be explained to me. I'm being followed.
Okay.
He called the cops. Congratulations.
Yes.
I'm coming to and from my house. Ooh, he's committing a crime. He's black.
No one's
He's
saying-
black.
Okay.
He's black.
I'm gonna explain.
Oh,
I'm gonna explain
I'm
why
doing
we're
my
here.
fucking paper route.
Okay, I understand that. I see all the papers in your car.
Yeah,
okay?
congratulations.
He just called saying that someone threatened his life. That's why we're here, okay?
Yeah, I threatened his life
So-
because I walked up to him and asked
Can
him
you
why
step-
he's following
You're
me.
not under arrest. Can you step out of the
I
car?
don't need to be under arrest. I don't. That's dumb.
Appreciate it.
You're gonna arrest
no,
me?
I'm not gonna. Come sit right here, okay?
Fuck, I'm working.
Sit on the bumper.
I'm
You got any
the
weapons on you?
No, I don't got shit on me. I'm at work.
We're gonna inspect it, okay?
Gosh, I got a fucking knife in my car
That's fine. I don't care about what's in your car.
to cut my straps on my newspaper.
Okay.
Nothing.
We
They
are
don't
good.
need nothing.
Yeah.
Nothing,
If you
officer.
if you
What are
just
we
wanna
here
talk
for?
with-
What are we here for? Search my car. There's
we're not-
fucking newspapers. This is the second time this shit happened to me.
What's your first name, sir?
The fuck? Sedrick Altheimer.
Cedric? Okay, Cedric. Okay, we just got a call saying that.
I'm in danger. Ooh, that's a fucking lie. Now what happens
That's
to
what we're
him?
here to figure
He's
out.
lying.
That's what we're here
He's
to figure
lying.
out, okay?
So what happens to him?
Was there any
What happens to a liar?
We will figure that out.
To get 4
okay?
cops here. How many
We will-
cops cars are here?
Cedric.
For a
Cedric.
newspaper carrier?
Cedric.
I don't need to talk. That don't make no fucking sense. I'm not under arrest, right?
You're not under arrest.
Okay, I can
No,
go, right?
No, you're not free to go either.
Why can't I go?
Because we're
I'm
trying
not
to
under
figure-
arrest? Who's a sergeant? Who's a
The
sergeant around
sergeant's on
here?
his way, okay?
Thank you. Please,
Cedric,
I'm not under
Cedric,
arrest, right? I'm
Cedric.
going back to work, right?
No, you're not leaving right now, but you're not under arrest, okay? Do you want me to put you in handcuffs?
This is dumb.
Right now, I'm
Ooh,
just...
you're gonna put me in handcuffs for what?
Cedric.
Because I'm talking?
Right now, I'm just talking to you man to man, trying to figure out what's going on, okay?
It's not a man-to-man conversation. Go talk to him. The one's so in danger. He's in danger. I got weapons.
Cedric.
I got
Do
weapons.
you see how
I'm
calm
gonna
I
throw a
am?
fucking newspaper
Do
at
you
him.
see how calm I am?
I pulled into his driveway. If I pulled into your driveway, I'm obviously your carrier.
Cedric. Just talk to me for a little bit, okay?
There's nothing to talk about.
Okay.
There's nothing to talk about.
Did you guys have any verbal altercation?
He's following me.
Okay.
I walked up to his car because he came around the block again for the 3rd time. I approached him. Why are you following me?
Okay.
Because I'm a black male in a white neighborhood? Oh, where are you at? I'm on the north end.
See, that-
Oh, you don't
that-
know
that-
where you're at? My wife is black. I don't care.
That's all we're trying to get to is what happened between you guys that made him call
I
us.
am working. I am driving a bucket and I'm in a nice neighborhood. I'm working. I'm over here every night. I see you guys every night. Nobody messes with me. But a car that sees a bucket in the neighborhood on the wrong side of the street, throwing a paper out the fucking window, he's suspicious. Oh, he pulls up to another house. He's going to steal a fucking Amazon package off that porch. Check my car. I got 15 Amazon packages in the trunk.
Cedric, I'm not saying he's doing anything. He's not saying he's doing anything. He just said there was an altercation. That's why we're here. Okay?
You guys can be doing so much. I'm glad. You guys should. One officer. Oh, you're following a newspaper carrier.
I'm going to be 100% honest with you. The reason there's so many cops here is because he's the sheriff. Who said that he got
I know who he
okay?
is. I know exactly who he
Someone
is.
threatened his life. We have no clue who you are.
The
Okay?
sheriff
So we
he's
get it.
threatened?
Okay?
He's so threatened. I knew he was a fucking cop.
So,
I'm over here every night. 6
Okay.
days a week.
we're with Tone Police. He's not our cop, okay?
Thank you.
So, we're totally different entities. We're just trying to figure out what's going on. That's why there's so many people here.
Okay.
Okay? Right. You're not in handcuffs. You're not in trouble right now.
I know I'm not in trouble.
Okay.
I am working.
But until we figure everything out and make sure everything's covered, okay, yes, you do have to talk to us. If you don't have to talk to us,
It's
you
a
have
big
to
investigation.
You see them leaving? Yeah.
Everybody needs to leave. You guys need to walk him home. Follow him home. He needs help. He needs assistance. I got 200 fucking...
So, on that tape, did you hear yourself say, "I know exactly who he is"?
Yes.
He's the effing cop?
Yes.
Okay. And you were referring to Troyer, right?
Yes.
And that was you acting differently than you're acting right now, right? You're pretty upset, what we saw in that video,
Yes.
correct? and you used the F word quite a few times.
Yes.
So I want to ask you some things that you told the Attorney General's office about this case. You had a number of meetings, or at least two, I'm sorry, I wasn't finished. I wasn't finished.
Sustained, yeah,
I-
sustained.
I wasn't finished with my question, Your Honor. Let me ask you this a different way. If I could continue, please.
My objection is reading from other people's reports.
I can ask questions if he said certain things, Your Honor.
You can ask
The
them, have you
objection
ever
is
said?
sustained with respect to identifying where the information's coming.
That's fine, Your Honor. I want to ask you if you've said some things in this case. Have you ever said that cops are trained killers?
Yes.
And do you remember who you said that to?
I don't know which conversation that was.
Did you ever say that the cops that came, the cops we're talking about here, they got me at gunpoint? Did you ever say that?
Yes.
And did you ever say, you thought, when you were asked initially about who you thought this person was, you originally said he was a strange man in the neighborhood. Isn't that what you first said? And then you later said, I knew who he was. He was the sheriff.
Yes.
Yes. You also said that Troyer's house has a ring doorbell. How would you know that? Did you ever say that? Let me ask you that first.
Yes, I did say that.
How would you know?
I can see it.
From the street?
Yeah.
And you've also said, when you've been followed before like that, it's usually a white male interested in a black man doing his job. Have you said that?
If that's what that one says, yes.
And you've also said that Troyer never blocked you into any area, isn't that right?
Yes. Yes.
Yes. Okay. And you said that he was holding a phone or he wasn't holding a phone?
I'm not sure.
Were you there when he called in for other units?
I wasn't listening.
Okay. Do you know whether he called for 1 or 2 units or 40 or 43 or 46?
No.
Do you remember telling anybody that you said to Troyer, if you're feeling in danger, call the cops?
Yes.
Okay. So that is what you said to him?
Yeah.
Okay. And did he do that?
Yeah.
As far as you knew, right?
Mm-hmm.
Have you ever called him Mr. Sheriff?
Probably at the scene, yes.
And when you flashed did you flash your headlights at Troyer at any time?
We had a flashing battle, yeah.
Flashing what?
We had a flashing battle.
Like a flashing headlights battle?
Mm-hmm.
And then did you ever say, I wanted him to know we are in battle, get the cops here? Do you remember saying that?
We were in battle, get the cops here?
Mm-hmm.
No, I didn't call anybody. I didn't have a phone that night.
I'm just asking if you ever said to anybody, when the flashing of the headlights, you saw him flashing his headlights, did you ever say to anybody, I saw him do it, so I wanted him to know that we're in battle, get the cops here? Do you remember saying that?
I just said no.
Okay. You were let go that night, right?
Yes.
You were never handcuffed, arrested, or prosecuted, right?
No.
And did you ever hear Sheriff Troyer say, once he learned that you were a paper carrier?
I didn't hear anything he said.
Okay. Did you understand that at some point he learned that you were a paper carrier?
Sure.
Okay. And did you ever hear him say at that point, he's working, meaning you, let him go do his job?
I can't answer that.
I'm just asking if you heard him say that.
No.
But in any event, you were let go, correct?
Yes.
Who did you first talk to in the media about this case?
In the media, Jim Bruner is the one that found me.
At the Seattle Times?
Yes.
And were you truthful in everything that you told him?
Yes.
Did you also talk to Joyce Taylor at King 5 News?
Yes.
And did you give her an exclusive interview?
Yes.
And were you truthful in everything that you said to her?
Yes.
We have, in your claim for damages, did you review that? I know your lawyer filed it, but in your claim for damages, were you ever given that to review?
No.
So you've never seen it?
No.
Do you know how much you're suing for?
Yes.
How much?
$5 million.
Okay, and how do you know that? Aside from what your lawyers told you?
Then there's no other explanation.
Okay. I could just show it to you. I don't know if we're going to break for lunch, but I could get this March on her. Thank you.
2 minutes more.
Okay.
So we're taking letter E.
Thanks. I'm showing it to counsel. Thanks so much. May I approach the witness, Your Honor? Thank you. Sir, if you could just take a look at this exhibit, which is E, and let me know if that looks like the claim for damages in your
Is
case.
that what you just handed me? Am I looking at what he's looking at?
I try to address my comments to the
Yeah.
court, not opposing counsel.
I'm just asking if we're looking at the same thing.
I'll take it back
Could you,
again and double check.
Thank you. Just
Does this look like the claim for damages in your case?
I've never seen it.
Thank you. Let me just ask you a couple of things. Is your name on it?
Yes.
Okay. And does it have the claim for the 5 million, up to at least 5 million on it? I'll show you where
This has been asked and answered 4 times now. It's a $5 million.
a little more leeway. The objection's overruled, the court will grant some leeway on cross-examination.
And this is just foundation for the exhibit.
But yes, actually, I do see it.
Did you actually see what?
I actually see what you're talking about.
Okay. Your Honor, we'd offer the exhibit. Thank you.
We object to a legal filing by his attorney going back as an exhibit. I object to the admission.
All right, this is,
This time, members of the jury, it's lunchtime, and I
Yes,
believe
you
your
are.
lunches are waiting, and
Thanks.
so I don't want to delay you eating them. So at this time, you're going to go ahead and go back into the jury room. No discussing the case and no research about the case.
Get up.
she never, she just starts talking.
Here, what we come back? The judge is gonna let us all know.
You're okay. I was gonna ask it.
Please don't yell.
Patience.
Spongy.
Yeah, you can stay there for right now. You can just stay there for just a second.
Oh, okay. Sorry.
I have no objection to witness stepping down, Your Honor.
The jury is
Oh.
outside the courtroom. The jury has left the courtroom, and I was going to ask counsel having objection to the witness stepping down at this point.
None, Your Honor.
State,
No, of course not, thank you.
someone have you back here by 1 o'clock, no later than 1 o'clock if you can.
Okay.
Thank you. And objection by the state. Defense, I wanted to give you a chance to make any record if you want.
Yes, I mean, that was.
And you can be seated. I mean,
Yeah. Oh, thank you. That was a speaking objection, and I would object to the continuing speaking objections, because we hear these objections that are kind of speeches, but I didn't hear a legal basis. It's his claim for damages, it's his name, there's the amount, and I think that it should be allowed into evidence. If not, I'm not understanding the legal basis for the objection, which is basically that it's a legal document prepared by his lawyer. That's all I've heard.
State.
Several objections, Your Honor. First of all, this is outside the scope of the motion to eliminate that the court granted. I specifically had made a motion about what could come in terms of the lawsuit, and the court granted that, which is it's pending, and it's for $5 million. And included in my motion was that getting into the legalese of that, which a lay witness would not understand, would be prohibited. and my understanding is that it was prohibited. He did not put this document together. There is a lack of foundation that even knows what's in it.
If I could, observers may be seated if you choose. I'm sorry, I should have told you. My apologies.
He has signed
Thank
the
you.
first page, but there is a lack of foundation to getting this legal document to the jury if they could even understand it. And it's also irrelevant, and it is outside the scope of what the court specifically allowed regarding the lawsuit.
Defense.
Your Honor, we're just pulling that up now, but this is his claim for damages. It's a precursor to filing a suit. It's not necessarily a legal document. It's his claim to the entity, the county, that's required by statute. But it's not a pleading. It's nothing like that. Did you pull that? Oh, thanks. Let me just take a look at the court's order so I've got it here in mind. And so that's all the foundation that would be required. The, find it here. Here's your order.
Can I interrupt on that? Are both parties agreeing that this is the claim that was filed? Because the witness testified he'd never seen it before, so there's no
I've never
foundation
seen-
for the document,
He
at
signed
least from
it.
this particular witness. But if the parties agree that this is the claim, I'll take that as a fact that the parties agreed to, not necessarily whether it's admissible, but because I've not seen the document, so I have no idea what it is, and there was no testimony from the witness as to what it was. I mean, so I want to make sure, is this the claim that was filed by Mr. Altheimer against the defendant and the county?
Your Honor, I don't know. I've never seen this document before. It was literally handed to me in court.
Your Honor, it's a public record. It's equally available to both parties. It bears his signature. It's a claim for damages. It lists the amount that he just testified to that he's requested in damages. His lawyer's here in court. Foundationally, it's a claim. He signed it. I'll have him verify that, but that's something that counsel could have found just by looking at the public record in the civil case. I mean, it's a claim for damages that you've got the required hiatus between filing the claim for damages and filing your lawsuit. I assume that's why it was filed. So it's not a quote-unquote legal document, but there's no lack of foundation.
Your Honor,
Other than, and the court, we discussed this earlier on motions eliminating. The court granted, and I'm not changing my mind about that a lawsuit is pending by Mr. Altheimer, that the amount of the claim was at least is at least $5 million, and that is something that exists that the jury should hear about. And so that's what the court ruled.
Right.
And that was, and the defense argument was because that would show financial bias. And the court agreed and agrees with the defense argument about that. It shows financial bias. Taking that decision by the court and then getting into the nuances of what may or may not have been filed by Mr. Altheimer's attorney, I'm just wondering what the relevance of those nuances would be other than the fact of a lawsuit to show financial bias. And that was the basis that the court admitted. That was the basis defense asked the court to admit it, of which I agreed. So when we're getting into nuances of the lawsuit itself, what is the relevance to this case and the elements in this case of more than what the court's already admitted concerning the potential financial bias of Mr. Altheimer?
Well, I think the jury's entitled to see that it's in writing and it's actually been put forward with his signature, aside from just saying I'm suing for $5 million. Second part is, touching on the complaint itself, he's made claims in his complaint for claims that clearly aren't supported by the evidence, in this case even per his own testimony. I think that goes to bias
This
too.
isn't a civil case. This is not the civil lawsuit, so
No,
why
it's
is that
not.
relevant?
It's relevant because if he comes in and says I was maliciously prosecuted, I was false arrested, none of those things happen. But those have been filed on his behalf, presumably based upon what he's indicated to his counsel.
Well, whether he was false arrested in a civil case is something to be decided in a civil case. I've not been asked to rule on whether he was arrested or not arrested.
No, maybe I'm not being clear on this, Your Honor. What I'm saying is, he's in this courtroom and he's telling us what he said happened. Yet he's filed a lawsuit saying, they arrested me, they prosecuted me. So that goes to his credibility. Those things are false.
There's been no evidence from this witness that the facts you just stated are something he knows about.
But you have to verify a complaint as a plaintiff.
Well, he hasn't even been asked if he signed the first page.
Well, I started on the complaint and drew objections which were sustained, but he has not signed it. I've got to look again, verifying the complaint, like you often see, as the court well knows that's what we require. But the fact is, it's his complaint. He has a lawyer. And what he says here is completely different, in our view, from what is in this civil case. And I think we're entitled to show the jury that, again, going to financial bias, the exaggeration, needing to win in this case with the higher burden of proof.
But what's that got to do with the nuances of what happened to be written by his lawyer?
Because it's
the
not
bias is he's seeking $5 million. That's the financial bias. The underlying basis for that is irrelevant to this jury. It might be relevant to the civil jury, but it's really going far afield from what whatever's in that particular document, which the court's not yet seen. What element does that go to beyond financial bias?
It goes to his credibility.
On something he didn't write and hasn't recognized.
Well, if he didn't write, didn't recognize, where did the facts come from? Where did the law come from? I mean, I'm just saying.
You could interview his attorney, I suppose, but that's speculating. That's just speculation. I mean, you're asking to have this case become a civil case where ultimately the facts of the civil claim, of which this person's not an attorney and wouldn't understand the legal nuances, and then ask the jury to decide whether the civil claim is valid, and if the civil claim is not valid, therefore this criminal case must not be valid, or Mr. Troyer did not commit this offense. And that's just way far afield under ER 403, even assuming the nuances are relevant. And I haven't even talked about that because I haven't heard much argument about that, but I don't see the relevance of what the lawyer filed on his behalf in a civil case to this case, except for the financial bias which the court has allowed the defense to get into.
Well, thank you. And it goes to the financial bias, but also credibility. I mean, there's a factual basis in every complaint, and there's one here. But to get to that, you're going to have this witness say, yes, I read that, yes, that's what my statement is, and then potentially for impeachment and or bias. And there's been no evidence in this case of any of those answers from Mr. Altheimer. Well, I think I started down that road but couldn't go there, Your Honor. But I understand the court's ruling. I'm ready to go forward.
But you couldn't go there because he said he never read it. I mean, if you're trying to impeach somebody on something they never read, that's the end of the impeachment. Unless there's some more information you can provide as to whether or not he in fact did read it.
Well, this is a public document in his case, and if he denies he was maliciously prosecuted, et cetera, that's fine. But what I'm saying is, they've sued. It's a $5 million claim, at least. The claims in here are not supported by the evidence, in our view, and I should be able to ask him about that. And it all ties together into the bias, the financial bias, which is, if he prevails here, so to speak, in a criminal case, probable cause, that he has a preponderance of the evidence standard met on certain of those claims. And I'm not going to ask him that detailed, but this all ties into that motive.
That's true, and you've been allowed to present that information to the jury with respect to financial. You've not been prohibited from discussing the lawsuit, discussing the amount, and why he would have financial bias to not tell the truth in this case. That's all been permitted.
I understand the court's ruling. I mean, I've made my record, I think, and I have nothing further unless you do. It's lunchtime,
Does it
right?
have any case law with respect to having a civil lawsuit be, the claim itself be introduced in a criminal case?
Yeah, we'll find that, Your Honor.
That would be helpful.
I believe we do.
That would be helpful to the court.
Thank you.
All right. The state's objection is sustained. Anything else from the state? With respect to, let me be more specific, this was Exhibit E. Exhibit E is denied admissibility.
Your Honor, I actually had one other thing on that, is that these are other statements of his, and if he says he didn't say these things, he can state that. So outside the financial bias arguments. That's all I have. Thank you.
And Your Honor, I know the court's ruled, but to be succinct in our objection, it is mostly under 403. They're trying to turn this into a mini trial on the civil issues, which the court is aware are much different than criminal issues.
Well, it's broader than that. It's under ER 401. It's also under personal knowledge. You're trying to solicit information from a witness that has no personal knowledge. That's just not permissible. And so it's broader than just ER 401 and 403 with respect to having this document admitted when the witness indicates that he's never seen it.
Well, Your Honor, I've made my record, but I also cite the Teglin at page 155. Even though the court at section 402:12, even though the evidence rules apply in criminal cases under ER 1101, the courts have occasionally said the defendant's constitutional right to a fair trial, including the right to present exculpatory evidence, may prevail over the rules of evidence in certain situations. And so I think in this circumstance, again, my client is the defendant. Even though he's the sheriff, It kind of feels like sometimes, that he's being treated in a way that he's not afforded, or at least seen by the media as not being afforded the same rights as an accused. But the fact of the matter is, this man's civil lawsuit filed in federal court. It's filed in state court. It's removed to federal court. And these, did they come out of thin air? I mean, you have to verify a complaint as a plaintiff. We can look for cases, too, about cross-examining from a complaint, which I've done before. I don't have cases coming to mind, but we will look over the lunch hour, too. But clearly, the claim for damages we've asked for about before in our police cases in Seattle and Portland, King County, everywhere, which is just your claim. This is how much you're asking for, et cetera, which I've just done. What I didn't ask him was about his signature yet, but that is his signature, and I think he just said that. So that's my record. We'll look for cases, and that's all I have. Thank you.
Thank you. Everyone have a good lunch.
Thank you.
Please be back here by 1:15.
Better.
Jeffrey Yons is presiding.
Thank you. Please be seated. And good afternoon, everyone. This is the State of Washington versus Edward C. Troyer Jr., Pierce County District Court, case number 1AC 002225. These proceedings are being live streamed through the Pierce County District Court website. Viewers are reminded, however, that they are prohibited from photographing or audio or video recording these proceedings without prior permission from the court. This prohibition also applies to courtroom observers. Only credentialed media, which have been granted permission by the court in advance, are permitted to photograph, audio, and or video record these proceedings as outlined in the court's November 4, 2022 media coverage order. To courtroom observers, jurors have a duty to decide this case based on the evidence presented. To ensure both parties receive a fair trial, it is my duty to minimize the risk that jurors are influenced by external factors. For that reason, courtroom observers are prohibited from wearing clothing or accessories with political or social justice messaging. If you currently are wearing or displaying anything that meets that description, please cover it up or put it away. And thank you for your cooperation. And to the state.
Your Honor, my apologies, I was updating the next witness.
Sure.
I do have one objection before we go back on record. The state had previously marked and it admitted State's Exhibit 15, and that is the note about the GoFundMe page that Mr. Altheimer testified to. Defense is now marked Defendant's Exhibit H, and with the court's permission, I'd like to hand them both up.
Your Honor, I really
I'm
don't
gonna
care
say
on these,
H.
as long as one goes in.
I'm
so.
sorry. Oh, okay,
Just to
then I
cut
withdraw.
to the chase and save a little time.
I appreciate that. Withdrawn.
Not asking for a ruling to be made, so I won't.
All right, thank you, Your Honor.
Defense, anything before we bring the jury back out?
No, Your Honor, just that we'd already made a record on the statements from the civil claim. We also believe that these are just statements of fact in the complaint that we should be able to ask Mr. Altheimer about. And we also will ask to have him subject to recall. If we don't have this issue resolved, as my office is working on finding the cases that we talked about, Your Honor. But we don't have those yet on the issue.
Well, how does a statement of fact make it relevant to this trial?
These are statements of fact he made. Either they're true or they're not. About this incident.
In the exhibit that we were talking about before lunch? In the claim? I want to make sure I understand what you just said.
Okay, no, I was talking about the complaint. And then in the claim, I think we have it up here. Do you have it here? There, is that the claim? I just have a moment, Your Honor.
Sure.
This one.
I show that Exhibit E, I think, is what you were
Okay,
discussing.
it is, Your Honor. Thank you.
Exhi-
Thank you.
Yeah. And is that Exhibit E to make sure?
Exactly, Your Honor.
All right. Please, go ahead.
So we haven't marked the complaint. Exhibit E is the claim. And yes, I mean, there's a statement of fact attached to it as part of it. Because the form asks, of course, describe how the loss incident occurred and the involvement of the county. And then it follows with a statement.
About this incident.
Correct.
Okay.
Lists the potential witnesses, etc., and it lists the claimant, and he signs it. I declare under penalty of perjury and under the laws of the state of Washington that the above is true and correct.
So it's Mr. Altheimer who signed it.
Yes, Your Honor. And I can hand it forward. Just so.
No, go ahead. Go ahead.
All right. So that's separate from what I have not marked yet, and that would be the complaint, just so I'm clear on my arguments. But I think the claim, frankly, would be sufficient for my purposes, given what's described there and described in the complaint.
And if I understand correctly from the procedural history of the civil case, the complaint is a legal document that was filed in a court somewhere based upon the claim that was filed with the county.
Exactly, Your Honor. A second copy. And that's all I have on that, but I think the claim clearly should be admitted, and I should be allowed to inquire into it.
State.
There's still a lack of foundation among other things.
Well, before lunch, the court was discussing looking at my notes, make sure that I have this correctly. The defense was seeking to admit the claim because it wanted to get into legal theories that were discussed in the claim, and the court denied that. Now the offer of proof by the defense is that they want to get into specific statements that Mr. Altheimer may have made within the claim, and that's a different request in a different legal theory. And so I've heard from the state with respect to legal theories, and my ruling is going to stay the same on that. But with respect to what I think the defense is saying right now is they want to get into potential statements about the case that Mr. Altheimer made within that claim document.
Your Honor, the way I am reading this, and you can hand it up, is there's a cover sheet for submitting the claim that was signed by Mr. Altheimer. But the way that I am reading this are that these are statements from his attorney. It's making it sound like he wrote this and he signed this, and that is not how I am reading this. And can I hand it up so the court can see what we're talking about?
Do you have Exhibit E?
It's right here. I put it right in the middle. Thank you.
And just to make sure we're all talking about the same document, this document is on the heading on the top left, says Claim for Damages, Pierce County. Are we talking about the same thing here?
Yes, Your Honor.
You agree?
Yes.
All right.
And there's a letter on page 2, signed by his attorneys.
I just want to look at it. Do you? It might be a little
All right, well, on the bottom page 1, if I'm reading this correctly, it looks like this was signed by an attorney, not Mr. Altheimer. Am I misreading this?
The first page has the claimant, and it has...
It says signature of claimant or authorized agent, and then there's a typed name, Susan Mindenberg, and a Washington State Bar Association number.
I just have a moment on it.
Am I miss?
Oh, okay, no, that's...
That is one of his attorneys.
We
Your Honor.
keep doing different ones.
Okay. So,
Oh, wait a minute,
at
Your
least
Honor.
based on Exhibit E, Mr. Altheimer's signature is not at the bottom of the page, if I understand correctly.
Not that I can see.
Ron, I'm just pulling it up on the computer. I just want to make sure, E is the claim for damages, which we've handed up to the court that's been marked.
Correct.
And separate from that would be the complaint.
Right, that's not been marked that yet, though.
Yes, thank
Okay.
you.
And then what looks like on page 2 of the complaint is a similar look, I'm not a signature analysis to be clear, but it looks like a similar type of signature from attorney Susan Mindenberg's, my apologies.
You just need one more minute, the computer's spelled out. You know. Your Honor, could the court indulge me and let me look at the court's copy?
Yes,
Thank you.
good idea.
System is not cooperating over here. Thank you. It's hard to read what the signature is. It's like 2 initials, but it does indicate I declare under penalty of perjury, etc. And then says claimant or authorized agent, as the court stated under the cites the RCW. But then it goes on to describe the date of loss, the incident, how much is the claim, and then there's a letter from counsel to Pierce County's risk management, of course, CCing Mr. Altheimer and the co-counsel Vonda Sargent with that statement of fact, which is the 3rd page of the exhibit. So I think we should be allowed to inquire into what's stated in the statement of fact, which is page 3 of Exhibit E, that claim for damages, then it lists witnesses. Thank you, and I'll hand it back up. I appreciate this. Thank you, Your Honor.
Okay.
Your Honor, again, this wasn't even signed by Mr. Altheimer. It wasn't signed, well, I'll just leave it at that.
Yeah, I just indicate this, she was an authorized agent for him in this filing.
Well, that's a different theory than whether it's signed by Mr. Altheimer on cross-examination of Mr. Altheimer as to whether his counsel on his behalf signed a particular document.
I would just indicate in the exhibit, and we'd offer it for, if it's not admitted before the jury, we'd offer it for the purposes of this argument, that the signature is just 2 letters.
Well, there's an easy way to solve this, and that's by testimony. So the court will allow the defense to present this Exhibit E to Mr. Altheimer and ask him whether or not he signed it. I mean, and if the answer is yes, well, the answer is whatever the answer is. I'm not going to speculate about that. And then we'll just go from there. Because I'm not going to assume a fact that I'm not testifying in this case. And so the proper way would be to, if the defense wants to, hand this to Mr. Altheimer, ask him if he signed it anywhere on there, and give him a chance to look at it, and then his answer will be what it'll be.
Thank you, Your Honor.
So for right now, the defense motion to admit Exhibit E remains denied. The defense offer to admit is denied. Anything else from the defense?
No, thank you. We're ready, Your Honor.
Okay, ready?
Yes, state's ready.
Could you please bring the,
We will be asking for Mr. Altheimer to be subject to recall. I don't want to announce that in front of the jury when we're done, but that's what we're going to be asking, given that there's some pending issues as to the civil complaint.
you would certainly have that right.
Thank you. That's all I have.
You can go ahead, coming up now. Thank you. There's no water.
Get it?
Yeah, they gave me a fresh cup.
The jury is returning to the courtroom. Thank you. Everyone may be seated. Cross-examination.
Thank you, Your Honor. Good afternoon, and good afternoon, Mr. Altheimer. I don't have too much more for you.
Sorry to interrupt, but Mr. Altheimer, you are still under oath.
Oh, thank you.
understand that?
Yes, sir.
All right, thank you. I apologize for interrupting.
Oh, thank you, Your Honor, for that. I had a few more follow-up questions. First of all, the other times that you were stopped by the police, you were let go every time, right?
Yes.
Was there any issue of race in any of those times?
I would say so, yes.
And did you raise that?
No.
Okay. And was that all here in Tacoma, Pierce County?
Yes.
And did anything come of any of those situations? Did you get charged? Was there a complaint by you? Anything that resulted from the stop?
No.
Fair to say that in each one of those, they saw something they told you was suspicious, but then when they saw you were a paper carrier, they let you go?
Yes.
Okay. And isn't that what happened here?
No.
Let me backtrack. Dark out, you couldn't see the sheriff, right? As he was behind you. as he's driving?
He wasn't driving directly behind me.
Any time before you went to his window, could you see his race in the car?
Yes.
At what point?
When we first passed each other, I noticed it was a white male driver.
Was that at his house?
No.
Was that at a house?
No.
You saw a white male driver, did you know it was the sheriff?
No.
Didn't recognize him.
Didn't recognize him.
Other than that, it was dark out, right?
Yeah.
You didn't have your dome lights on, right?
Mm-hmm.
And neither did he, right?
Mm-hmm.
You already testified earlier today that there was no mention, no racially disparaging or discriminatory comments made towards you by Sheriff Troyer, isn't that right?
No.
Just so we have it clear, he never made any racial comments.
Sorry, yes.
Thank you. I know sometimes a double negative, and I apologize for that. You don't know when he first learned that you were a newspaper carrier, but obviously he learned that at some point. Isn't that fair to say?
Yes.
Okay. And the whole situation, insofar as you were concerned, changed at that point, correct?
I don't know.
You never told him you were a newspaper carrier,
Mm-hmm.
right?
Yes.
And you didn't deliver newspapers that night in his presence, isn't that right?
Ask that again?
I'll strike that, actually. Just let me ask you this. He had no way of knowing. I'm sorry.
Me be able to answer that question. The state didn't object to it.
Your Honor, this is cross. I'm trying to rephrase it.
Overruled. You can rephrase the question.
Thank you. Based on everything we know, everything you know, you were there. The only two people that were there before the police responded were you and Sheriff Troyer, right?
Yes.
Okay. So based on everything he knew, or would have known or should have known about you, until the time you came up to his car, he wouldn't have known that you were a newspaper carrier, would he?
He could have.
But did he? Was there any reason he would know?
I was throwing papers out.
You were throwing papers out while he was following you?
Yes.
Okay. What street?
Vista View.
Which house?
I can't remember directly what address, but I delivered to two of those houses. I pulled in the driveway and he was sitting right there.
Whose driveway?
Just a driveway that was across the street.
So he was sitting in someone else's driveway at 2 in the morning?
I didn't say he was sitting in the driveway. I said he was parked on the street.
By his own house?
By his house.
Okay. And you're saying that you delivered papers in front of him and then he followed you?
Yeah.
Are you sure about that?
I don't know what you're asking me.
All I'm asking is whether he should have known or he knew that you're a newspaper carrier.
I can't tell you if he knew or no.
That's my question. Okay. And you didn't tell him that you were one ever, did you?
No.
I've written a note here, and maybe I didn't get it right, but you said something about that he looked suspicious where he was, that the sheriff looked suspicious. Did I hear that wrong? Write it down wrong?
I don't recall that.
Okay. Did he look suspicious to you?
Creeping around, yes.
What do you mean by creeping around?
Like I said, I'm doing a job. I'm working. So I have a set delivery route that I know for years. And there's an SUV popping up corresponding to houses that I would approach. And this SUV would sit there, park, and watch me the first two X's. Well, the first X was a drive-by. The second X, he watched me. The third X, I approached him.
Did you know that the map that he's drawn of the route that you two took was only a matter of a handful of blocks?
Sure.
Okay. Yours is much longer, isn't that fair to say?
Yes.
Okay. Do you know why there's that difference?
Somebody's telling the truth and somebody isn't telling the truth.
And that was my question. Any witnesses along the way?
All the cameras.
And we've seen those body cams, right? of the officers that came later.
Yeah.
You said that Sheriff Troyer had a doorbell light. Do you remember talking about that?
Yeah.
And how did you figure that out?
When I threw the newspaper, you seen a green little circle light down by his back door, or I don't know if it's the front door or back door, but
Is that the newspaper we were talking about here, Exhibit C?
yes, January 28th.
28th, I think.
Yeah,
And it has the way that you wrap papers so you knew it was yours.
yeah.
Would it surprise you to know that he didn't get a ring light until after this case became publicized and charged?
evidence.
Sustained. No, sustained, you don't need to answer.
Are you sure that he had a ring light back then?
Yes.
Okay. And where was it located?
I said by a door.
The which door?
By the door that's downstairs, I don't know.
And where is the door downstairs?
Downstairs on the end of the driveway.
Left of the garage, right of the garage?
I don't know. It's been so long.
You, there was an indication you said that you were told to have, or you do have at times, your lights off sometimes, but you've also testified that you have your lights on in general. Which is it?
I have my lights on all the time.
Do you know why, then you said, and it's indicated in the case, that the police told you to turn your lights on? Do you remember that testimony? Or anything in terms of the statements?
No.
Being told to turn your lights on?
No.
Do you ever turn your lights off when you're going in someone's driveway? So
No.
you don't shine the lights at 2 a.m. into their house?
No.
Okay, so you're okay with doing that?
Yes.
And you park in people's driveways because you get more of a tip if you take the paper up to the porch, right?
If you say that, yes.
I think you said that yourself, didn't you?
So, if you want to clarify that part,
Mm-hmm.
the people that tip me and take care of me, I usually get their paper closer to their porch or their door for them.
Is there any time that you just, I think you described earlier, where you drive down the street and throw newspapers from your car without getting out?
Yes, ma'am.
And when you go through your route on a regular basis, does it consist of throwing papers, going up to doors, and a mix?
Depends on the weather.
Do you know what any of all these complaints were, or back in the exhibit, which was B, some 4,000 complaints?
Yeah.
What were they?
Missed deliveries, wet papers, failed to put it in the right location.
About 4,000 of them. Does that sound about right?
I guess.
Your employer testified about these, but your employer also testified about the fact that he's been stopped, too, delivering papers.
Mm-hmm.
And what is his race?
He's white.
And has he ever told you that he's been stopped, too, just because it can look suspicious the way someone would be delivering papers at certain times and in certain ways? Has he ever talked to you about that?
No.
Have you ever complained to him about the times you've been stopped?
I alerted my boss to let him know about the Troyer situation.
Did you alert him about any of the other 10 times or times you talked about?
Only if the cops were called, if it was that serious.
You had a GoFundMe page, right?
I didn't have a GoFundMe.
Right, somebody else started it for you, right?
Yes.
Gee, great. How about you got an extra one of this? Did you need that one?
Is that an extra?
It is.
Sure, I'll take it.
For once, I might do that.
Sure, I'll take it. Thank you.
May I approach, this is Exhibit G, thank you. May I approach the witness, Sean?
Go ahead.
Thanks. I'm showing you what's been marked Exhibit G, and could you please take a look at that and see if you recognize what I just showed you?
Yeah.
What is it?
It's the GoFundMe page.
And that's your picture?
Yeah.
And it was set up for you for what purpose?
For me to get a new car.
Who set that up for you?
Carmen V.
And did you know her, or do you, let me ask you this, did you know her?
No.
Okay, do you know her now?
Yes.
And this was to get you a new car, but I think you testified earlier, you told Officer Lawless you had 3 cars.
Sure. Yes.
Your Honor, we'd offer Exhibit G.
State.
Yeah, I'd like to know why part of it is blacked out.
I don't know.
Well, it's your exhibit, and the name of who set it up is blacked out.
Your Honor, if I just have a moment, this is just identification, people's names go in these when they contribute.
A name we've been talking about this whole time.
Right, this is to protect the privacy of the names of people who have donated, and just by an offer of proof, Your Honor, to GoFundMe page, each person, unless they want to stay anonymous, will have their name and their amount of donation. And so those are blacked out. I don't think it's relevant for the jury. I think it's important for people's privacy if they wish to donate to anything, that they don't have to be submitted in an official court document in a high-profile case.
Ms. Tratnik.
Your Honor, perhaps if you could see the exhibit, the names of the
I'm happy to
donors
do that.
are not blacked out. The only thing that's blacked out on here is the name of the person who set up this page.
I don't know. No, I don't know. I just have a blacked out copy. Do you have one that's not? It's not. Hold on, I think there's not. I don't know why we're arguing about
Anything else from the state?
I'm arguing about it because it says blank is organizing this fundraiser, and blank is blacked out, and I would like to know why. It's not a donor name.
Your Honor,
And it's a name that's been testified to in court this whole time.
Any other objection?
No, Your Honor.
Objection overruled. Exhibit. I don't have the exhibit.
I think it's
Let me hand that one back.
G, Your Honor.
Oh, but I was handed up something that it doesn't show Exhibit G on it.
Is the actual,
With
Right
the
here.
witness.
Oh, of course. Yeah, thank you.
Thank you.
Exhibit-
So you better watch me.
Exhibit G is admitted.
Thank you, Your Honor. So this, you
I
gave-
don't want to say, the objection goes to weight, which the state can inquire about if it chooses.
Thank you, Your Honor. So you mentioned a name before of the person that organized this, and what was that person's name again?
Carmen V.
Okay, and is Carmen in court today?
Honestly, I don't know.
Was she in here earlier?
No. I don't know.
But she's the one that organized it to get you a new car based, I guess, on what she'd read in the news.
Yes.
Okay. And have you received this money?
Yes.
And have you gotten a new car?
Yeah.
Yes?
Yeah.
Okay. And is this still active?
No.
Your Honor, we offer the exhibit with request permission to publish it to the jury on the Elmo.
State?
No objection to publishing. I think it's been admitted, correct?
Granted.
Thank you. Thanks. It's a minute, right? Yeah, it's Are we able to see that?
It popped up, but it disappeared. Oh, it's back. It's back.
You can see it now?
Yeah.
Okay, thank you.
And can you see that all right on your screen, sir?
Yeah.
So here it says new car for Sedrick Altheimer, GoFundMe, share, donate, etc. And then it's got some blacked out amounts that people donated. And some people say anonymous on those and some leave their name, but we're honoring their privacy and not putting their names up there. The other part blacked out is the person who started this, who you testified her name twice now, so it's public. Total amount collected, $8,865, raised of a $20,000 goal. Does that look right for your GoFundMe
Yes.
page? Now, you said in a defense interview that you hadn't bought a new car yet with this. Do you remember that?
Objection. Fact not in evidence, and
Overruled.
Do you remember saying that in the interview with my office?
Which your office?
Wasn't at my office, with my office. With Mark Conrad, with Karina from my office.
No, I don't.
Do you remember saying that?
I don't recall off the top of my head me saying that.
Okay. And what kind of car did you get if you got a new car?
A Toyota Camry.
Make, model?
Object to relevance at this point.
Court will give some leeway, granted.
It was a 1997.
All right, sorry. The objection's overruled.
Thank you, Your Honor. You've had some meetings with the Attorney General's office, isn't that right?
Yes.
And with the media, isn't that right?
Yes.
And when you had meetings with the Attorney General's office, it was with these two lawyers here, is that right?
2 of the times, yes.
Okay, and there was probably an investigator there too?
Yeah.
And how many meetings altogether have you had with the Attorney General's office?
2.
How long did each one last?
Hours? I don't know.
Hours?
Yeah.
And did anybody take notes in the first meeting, if you remember?
I'm pretty sure they did.
Did anybody record the interview or meeting with you, like with a tape recorder?
No.
Okay. Did you ever have a meeting with just these lawyers here and nobody else?
Yes.
Okay. And how long did that meeting last?
About 30 to 40 minutes.
What did they tell you?
To stay consistent. Tell my truth.
Anything else? Did you know that they never created a record of that meeting with you?
Object to
Sustained.
relevance.
Sustained.
Um,
Sustained. You do not need to answer that question.
Do you know why they met with you, but with just the two of them?
as far as I know, it was protocol. I don't know. I was just scheduled a meeting and I showed up.
Okay. You talked to the Seattle Times, Jim Brunner, right?
Yes.
Okay, did you go to his office?
No.
Did he come to you?
Yes.
Who else was present for the meeting?
It's just me and Jim.
Me and who?
Me and Jim.
And Jim Brunner, okay, thank you. And did you tell him that, first of all, this is the first press interview that you had done, right?
Yeah.
And you testified before, and you've indicated you didn't know how he found you or got a hold of you, right?
Mm-mm.
The headline of Jim Brunner's article was Black Newspaper Delivery Driver Detained After Pierce County Sheriff Claims Then Recants Threat to Life. Remember that headline?
Yes.
And they had a picture of you in the article. Is that right?
Yes.
Who took that picture?
Some lady that worked for the Seattle Times.
This is a photographer for the Seattle Times.
Yeah.
And did you try to be as truthful as you could be with Jim Brunner?
Yes.
Okay. Did you tell him, first of all, you said to Troyer, if you have...
Your Honor, I'm going to object if she's going to quote to an article in the paper. It's hearsay, among other things.
Sustained.
Have you stated, I disagree with, I'm not going to make a speaking response, Your Honor.
Oh, you just did. Members of the jury, I'm going to have you go back to the jury room. Please do not discuss this case with anyone, nor do any research.
You're right, Your Honor. I apologize.
Thank you.
Thirsty, man, thirsty. Thank you.
The jury has left the courtroom, and thank you, everyone. You may be seated. Ms. Bremner.
Yeah, I'm sorry, Your Honor. Maybe I'm confused. I'm not aware of a rule that says I can't ask what he said to a reporter.
But you didn't do that. You were trying to read from an article, assuming the article was quoted is correct.
Oh, I'm
and
sorry.
then and you most certainly, and I'm going to give you wide berth on the ability to ask what
Okay.
this witness may have told some people. But if you're quoting from a newspaper article, that's a big assumption that that quote is correct.
I'm with you on
When
that.
you're identifying the source of the quote, I'm not saying that any media reports are correct or not. It's just they're not here to to produce that information. And so asking what he said is what this witness told the media is fair game for you, and I've ruled that already, so you're going to get to do that, but not if you're going to quote from a specific article or a headline and then ask this witness to comment about that.
I get it now.
And so the objection's sustained for that reason, not that you can't inquire, but for the reason that, and the state's mentioned this a couple times, and so that is the basis of my objection.
Understood. Thank you, Your Honor. So if I simply say, did you indicate X, without saying it's in the article?
Oh, of course.
To Jim Brenner. Okay, I'm ready. Thank you, Your Honor. I just wasn't understanding the distinction, but I do now.
And if you're going to comment to the jury about whether you disagree or not disagree with the court, I'd ask you to do that outside the presence of the jury.
I'm happy to.
You're entitled to disagree. That's totally appropriate. I can understand that, but the jury shouldn't hear that.
No, thank
And so please don't do that.
No, I won't, but sometimes I get speaking objections, and so I feel like I have to respond on the content at the time. And that was my intent, and I don't want to indicate any disagreement with the court, which I may have from time to time, not very often. But I've had more speaking objections in this case than I'm used to.
State, anything you want to say?
Just a brief response. I have no objection, as the court said, did you say this? Did you tell him that? Did you tell him that? And I'm not accusing Ms. Brenner of doing this, but I have seen other attorneys in other cases then make it really clear, you know, that they're reading from the article, and that's really my concern.
Well,
I think the questions need to be asked without hinting that this is in the newspaper.
the questions with respect to whether there was an interview with a newspaper or a news media outlet, those are appropriate foundational questions to explain the context. What Ms. Brenner may or may not be reading off of, I'm not going to get involved with what she's reading from. There could be her notes, it might be the newspaper. I understand what the state's saying, but so long as it's not indicated by the defense, this newspaper I'm reading right now, which the court is going to prohibit, that's really all I have to say
I'm
about
good with
that.
Thank you.
Yeah, that's really all I have to say about it. And your experience in other cases, I've not observed that here, and so we all have different experience with other cases, but I'm going to focus on what I see and hear from this case. So how Ms. Brenner wants to conduct her cross, she's free to conduct how she wants, and then if there's objections, fine. If not, then I'm not going to get involved.
Thank you,
Your
Your
Honor.
Honor. I'm a little worried about what the court said right before they went to the jury room, when I said, I don't want to disagree with the court, and you said, I just did, and then you sent him out like I have gotten in trouble or something, and I think that at some point, not now, but just rereading the comment on the evidence instruction, that if the court's comment on the evidence, to disregard, et cetera.
Your statements are not evidence, counsel.
Yes. I'm sorry?
Your statements are not evidence.
Right, I'm just saying what
So
you
there's no comment on the evidence I could have made because your statement is not
Oh, I
evidence.
understand what you're saying. All right. Thank you, Your Honor, and I'm ready.
All right. State ready?
Yes, Your Honor, state's ready.
Can you please bring the jury back? The jury is returning to the courtroom. Thank you. Everyone may be seated. Give the jurors a second here. Everybody looks ready. Your next question, Ms. Bremner.
Thank you, Your Honor. Did you tell Jim, did you pronounce it Bruner or Brunner when you talked with him?
Jim Bruner.
Bruner, okay. Did you tell him that one of the officers had drawn a gun?
Yes.
And did you tell him that you were really shocked? They definitely scared me.
Yes.
And that you were yelling, what are you guys here for? What am I doing wrong? You guys are trying to arrest a paper carrier. Do you remember saying that to Jim Bruner? Were you saying that loudly like we saw in
Yes.
the tape?
Sorry.
Was it loud enough for the sheriff to hear, do you think?
Oh, I don't know.
Okay, but you were yelling, you're arresting a paper carrier. Is that right? That's what you told Jim Bruner?
Yes.
Okay. Did you tell Jim Bruner anything about anything you said to Sheriff Troyer?
I probably told him, 3 questions I asked.
And those were, why are you following me?
Mm-hmm.
And then the next one was, are you a cop?
Yeah.
And the third one was, are you doing this because I'm black?
Is it because I'm black?
Is it because I'm black? And that's what you told Joyce Taylor, like you testified earlier at King. And when you said those things, you've already told the jury everything the sheriff said back to you. Is that fair to say?
Yes.
Did you also tell him that you went back to the sheriff's house and that Troy didn't get the newspaper delivered to his home?
I'm not sure if I told him that part.
Did you tell him you tossed a copy of the News Tribune in the sheriff's driveway because you said he didn't subscribe, but I wanted him to? I said, hey, come join my business so you know I'm a trustworthy man of your neighborhood.
No.
Did you tell Jim Bruner that's what you said to Sheriff Troyer when he came back to his house?
Yes.
Was that at 4 a.m. about?
Yeah, you can say that.
I'm sorry.
You can say that.
Okay. And when you talked about the cars, one being a gorilla and one being a monkey, were you talking about your car and Sheriff Troyer's car?
Yes.
Did you ever see Sheriff Troyer get out of his car?
Not until the cops showed up.
But when it was just the two of you, he never got out of his car, did he?
No.
Was this more of a he said, or were there other witnesses at all as to this quote-unquote conversation that we're dealing with in this case?
Just me.
Just the two of you.
Just me and Troyer.
You've indicated that you were afraid for your life.
Yes.
And we talked about a battle with him, that was about flashing headlights, or was it about something else?
It was about flashing headlights.
When you talked about the flashing headlights, did you say, get the cops here?
No.
Did you ever say, I saw him do it, he was flashing his lights, so I did it, like a battle, and then you said, get the cops here?
You're adding too much to that sentence.
With the court's permission, I can read it.
I mean,
He's given his answer.
All right. Did you ever tell that to the Attorney General's office?
I'm not sure.
Is it your assertion that you were racially profiled,
Yes.
even when he didn't know your race?
I can't answer that.
Even when he used no racial terms in talking to you, correct?
You don't? Yes.
Okay. And where he didn't know you were a paper carrier, the time you had contact with him?
He could have known because he followed me.
But you can't say he did know, can you?
I mean, I can, but I can't assume that he's seen what I was doing.
Right. So you're basically saying that this was kind of a non-event, that you had a conversation, the 1, 2, 3 things you asked with the sheriff.
Mm-hmm.
He didn't use any weapons, he didn't threaten you, he didn't disparage you in any way. You're the one that came to his car. He was sitting in his car. And it's your testimony that based on that, he called for police officers to come to the scene, right?
Mm-hmm.
And do you know if he called for 40?
I don't know that.
And when he said he was calling, you knew if he was calling on his back line, or did you know he was calling 911?
I don't know that.
One way or the other, right?
Yeah.
And so, but based on this kind of non-event that you're describing, all this happened, right? You had police officers at the scene, headlines, this case, etc. That's based on your testimony, that nothing really happened, correct?
I'm saying no. Something did happen. I almost lost my life for a lie.
We've already established that you didn't have guns pointed at you, right?
If you say so.
But the police say so.
The police say so.
Objection, argumentative.
It's cross,
Sustained.
Your Honor. So based on this whole non-events, we have this case and the other things I just mentioned, and you're telling this jury that you never threatened the sheriff, you never said, I'll take you out, I'll take you down, anything like that.
No.
You never said anything that could be termed threatening to the sheriff, is that right?
No.
Okay. So they all responded based on what we've just talked about, a non-event, correct?
If that's what you call it, yes.
That is what I call it, except for today. Thank you.
Redirect.
Briefly, Your Honor. Mr. Altheimer, why are you laughing?
Um,
I object,
It's-
that's not a question.
It is a
That's the
question.
question. It's overruled.
I'm laughing because she's calling it a non-event, and it's a pretty traumatic event. It's a significant event, and a lot of cops were attracted to the scene for a response or a saying that somebody had been threatened to be killed or he was in harm's way at the time. So I just chuckle because it's just a non-event. So I don't know.
How did you know there were guns drawn?
When you are sitting in a vehicle and you are black and cops surround you, guns are drawn. They don't know what my threat level is. They didn't know who I was. And they came to that scene because somebody had lied to them to make a bigger deal.
This neighborhood that you drew out on State 4, you kind of went down here, and can you see me? I'm so sorry. There you go. Went down below the page, and it went up here. And then this is the third stop, right? The third time when you see Sheriff Troyer, right?
Yes.
I'm sure that I'm blocking the jury. This route, before you leave and go to Deerfield Circle, how long approximately had you been on that route?
Since 2019.
Okay, and were you delivering papers throughout that route?
Yes.
I asked you some questions, oh, sorry, go ahead and sit down. I asked you some questions earlier about GoFundMe. Do you recall that?
Yeah.
I'm looking at, is that G? Let me see. I'm going to hand you back. Huh.
It's still right here.
Oh, okay.
It's on the thing.
Thank you. Defendant's Exhibit G. Do you see where it says, is organizing this fundraiser on behalf of Vonda Sargent?
Yes.
See that? Who's Vonda Sargent?
My lawyer.
Did your lawyer have anything to do with setting up this GoFundMe page?
No, she did not know about it until I told her about it.
When you set up a GoFundMe page, then how is her name on it?
When asked to when asked to be the beneficiary, I didn't have a bank account, so I asked my lawyer if she can do it for me.
And when you say when asked to be the beneficiary, but asked by who?
Carmen. But it's like on the website being asked to sign up beneficiary.
And then when Ms. Sargent's name was listed, did the money then go from Carmen to Ms. Sargent to you?
It went directly to my lawyer, and then my lawyer took care of it from there and by giving it to me.
Oh, no, that was talk up, but if you want to sit up, that's true too. I can
Sorry,
barely
I
hear you.
So, can you ask the question again?
Did the money eventually get to you through your attorney?
Yes.
How is it that Jim Bruner got in contact with you?
Objection, lack of foundation.
Overruled based upon the cross-examination. And, well, if he can answer the question.
How did he get in how did you first hear from him?
He contacted family. He got a hold of one of my aunties, and my auntie then called my mother, and then my mother then called me.
So did you seek him out, or did he come find you?
He came and found me.
And Mr. Altheimer, when did it click in for you that not only was the person who was questioning you a cop, but that he was not just a cop, but that he was the sheriff?
After Ventura told me, if that's the officer's name, the one that was talking to me on the left.
And then when you threw a newspaper in the sheriff's driveway, how did you know where that was?
Because of the white trucks.
Were there any other vehicles in that driveway?
That night, there was the garbage can and the white truck, and I can't remember.
If you don't remember,
Yeah,
just say you don't remember.
I can't remember.
Okay, and my last question, you had testified about making statements to the defendant about being in danger, correct?
Yes.
When did you make those statements to him?
I didn't make those statements directly towards him. I was talking to the officer out loud.
Might you have been talking very loud?
You can say that.
You had testified that the defendant called you a porch pirate, correct?
Yes.
Do you believe that to be, did you take that as a disparaging characterization?
Yes.
And my last question is, why did you fear for your life that night?
Why?
Yes.
Why is because of the SUV just constantly just pulling up on me, watching me, and not knowing what was going to happen around the corner or what was going to be the next step for him coming out of his vehicle. And I don't know, it's just a lot to take in.
Was that the only time that night that you feared for your life?
No.
When was the other time that you feared for your life?
When the cops showed up.
And why did you fear for your life at that point?
And asked and answered.
Overruled.
Cops aren't nice to black people.
No further questions?
Just remember, we're close to taking a break. We started a bit late, so I could go a little long, but just a few minutes. So what's your preference as to whether we cross, whether you want to just take a few minutes or take the recess so you have more time after?
Recess is fine.
That'll work, all right? All right, members of the jury, at this time, we're going to take the afternoon recess. No talking about the case with anyone and no research, please.
I can't leave, Christine? No, I'm like I can't leave at all.
After the jury leaves, yes. We'll just let them clear out first.
Yeah, but
The jury has left the courtroom. You may all be seated. Yes, you can sit down for now, but don't leave.
yeah.
And time for our afternoon recess. Please be ready to go by 5 minutes to 3. So 15-minute recess. Court's at recess. entering the courtroom? Are there any other people?
No, no.
Thank you. Everyone may be seated. Jurors look ready. Recross-examination, Ms. Bremner.
Thank you, Your Honor. Just one question for clarification. Mr. Altheimer, when I said a non-event, I was referring to everything that happened before the police were called by Sheriff Troyer. You understand that?
I mean, yes.
Okay, that's all I have. Thank you.
Redirect.
No, Your Honor, thank you.
So you may step down at this time. All right. I can go home. I'll have you talk with the state. State's next witness.
Is Officer Lawless, which brings up the motion.
Oh, some matters that the parties would like to discuss with me?
Mr. Gresham.
Yes.
Yes. All right. That's fine.
That's our last witness, Your Honor.
Oh, all right.
There was potentially initially a smaller witness in there, and we're not doing that.
Oh, all right. And the defense is aware of that?
Yes.
All right. Members of the jury, this time I'll have you go back in the jury room, and no talking about the case with anybody, and no research about the case. No. He's subject to recall. The jury has left the courtroom. Everyone may be seated. Thank you. Yesterday, the state had indicated it may be calling Officer McRae as well, and it sounds like the state has chosen it's not going to do that in this case in chief.
Correct, and we forgot to let the court know that, and when it clicked in that you didn't know that, that's.
All right, and the defense has indicated they are aware of that. So if I understand correctly, the state has one Officer Lawless remaining as its final witness before it intends on resting in its case in chief. All right. The matters the parties want me to hear outside the jury's presence concerning Officer Lawless.
I believe they're asking the court to reconsider its prior ruling about invocation.
That's correct. And we filed a motion to that effect, Your Honor.
Correct, and I received it. Thank you. I've read what the defense has presented. Defense, I think I'll let you make a record on that motion if you want to add anything additional to what's been written. That's now would be the time.
Sure, we've highlighted in particular this case, Ruiz, and what this case stands for is that a person who invalidly invokes the Fifth Amendment, that a party who's, I guess, a defendant can, or actually in that case it was a prosecutor, but a party can argue that a party who invalidly invokes the Fifth Amendment can be questioned, or that fact can be pointed out if it's relevant to the case. And as we set out in this brief, it's relevant in this case that Officer Lawless continuously invoked the Fifth Amendment for a few reasons. One is that Officer Lawless refused to sit for a defense interview, forced a court-ordered deposition, and then invoked his Fifth Amendment right invalidly to every question the defense asked during the course of that deposition. Additionally, when the state asked questions of Officer Lawless, he never invoked the Fifth Amendment. He also agreed voluntarily to meet with the prosecutors and did not invoke his Fifth Amendment at that meeting. So all of that is to show that, and as is the case in Ruiz, that the person that's invoking the Fifth invalidly is doing so in impeding the defense gathering of information. And so that's exactly the case with Officer Lawless. And also, as pointed out in this motion, defendant in a case has a constitutional right to cross-examine a witness about their bias and credibility. And in the case of Orn, as we've discussed throughout this trial, the defense has an especially wide latitude to do so if the witness who's testifying is a material witness. And Officer Lawless is about as material as it gets. So that's all I'll say for now. I'll hear what the state has to say.
State, thank you. State, Ms.
Thank you,
Drednick.
Mayor. First of all, the witnesses in this matter, as the court is very well aware, we're not willing to talk to either party. I think it is incorrect to say that they were not willing without their attorneys and invoking to talk to the defense. That's not true. It was either party. It was the state that moved to get the orders under 4.6 so that these witnesses could be interviewed. And this reference to they answered all the state's questions, that is literally that defense asking all of those questions in the deposition of Officer Lawless that the court was present for. And then at the very end, there was this thing about meeting with the prosecutor for literally a couple of minutes, and there were some questions back and forth. And those were the only questions that the state asked to clarify what was actually going on there. And that's the only time the state asked any questions. I'm looking at the 2022-23 version of Tegland, and at the bottom of page 256, it says the assertion of a privilege does not constitute an admission of any kind. Assertion of the privilege may not be the subject of inquiry or comment by opposing counsel. And that's the Sumter case at 194/598.
Now, aren't they talking about the ER 501? Isn't Tegland talking about the ER 501 privileges that are listed there and not the Fifth Amendment privilege against self-incrimination?
Okay, well, I think it's by analogy something to consider, but that is a good point.
And I think in this particular one, that Tegland's talking about the attorney-client privilege, not the Fifth Amendment assertion, which are different.
My apologies, Your Honor, that's a misread on my part. I did just look up a little bit of case law, and I'd like to read that for the court. Again, we got this late last night. We actually had a power outage, Mr. Serrano and I, where we were working, but I would like to read this into the record. Implicit in the Fifth Amendment privilege is the assurance that exercise of that privilege will carry no penalty. Doyle v. Ohio, 426-610, 1976. No inference may be drawn from an individual's exercise of his or her Fifth Amendment right. State v. Upton, 16 Win App, 195. Quote, neither side has the right to benefit from any inference the jury may draw simply from the witness's assertion of the privilege, either alone or in conjunction with questions that had been put to him, end of quote. United States v. Johnson, 488 F. 2nd, 1206.
Do those refer to the defendant asserting the Fifth Amendment privilege or to a witness in a criminal case, not the defendant?
I believe the defendant or a co-defendant. And then we have this brief that we then got this morning about, or I'm sorry, last night, the Ruiz case. And Your Honor, I don't think that's at all on point in this at all. What happened in State v. Ruiz, the court said that the defense objected to the testimony of a witness, which I believe was a co-defendant, barring any party from introducing a negative inference from an individual's valid assertion of the Fifth Amendment right. And then the Court of Appeals said, as there was no basis for claiming the protections of the Fifth Amendment, the trial court did not err by allowing the state to call Mr. Mendez-Reyna to the stand. And then the court further explained, and this is in the block quote from their brief, the state is not attempting to exploit a privilege, but rather is attempting to gain evidence from a witness who had no legal basis to decline to provide the information. So in that case, they were permitted to bring a witness to the stand and force him to testify because the privilege was invalid. Here we have a completely different situation where the court was present during all of these depositions. People invoked, the witnesses invoked, the court overruled, and they answered each and every question. And as the court knows, they were doing that on the advice of counsel. And what the issue is here now is should they, given that those witnesses who have answered all of the questions put to them and are now going to testify and not invoke, should they be allowed to comment on the prior exercise of a constitutional right that they invoked at the advice of their counsel? And there can simply be no reason for them wanting to do that than trying to get the jury to draw some kind of impermissible negative inference from that. And all the case law says,
What would be that, what's the state's concern about what negative inference the jury could draw?
well, it makes it look like he's hiding something. He's acting on the advice of his attorney and invoking a constitutional right. And we as lawyers all get the invocation of a constitutional right, but all the jury hears is he didn't want to talk and he had to be forced to talk, so he must be hiding something. And whether you're referring to the defendant or a witness, all of this case law says you can't exploit that. You can't use the exercise of a constitutional right to draw any inferences. So at best, it's completely irrelevant that he previously invoked. And if it's irrelevant, then why do they want to bring it up? Well, they want to bring it up to draw a negative inference, and that's exactly what the case law says you can't do. I don't see any change between the ruling we previously got on this and the Ruiz case, which is completely different, right? Ruiz doesn't stand for the fact that when you exercise your right and you answer all those questions, that you can then bring that up in front of the jury. That's not what that case says at all. It's inapplicable.
What is the state's perspective on this court's denial, and I'm talking only about Officer Lawless now, we don't need to talk about the other ones, but Officer Lawless, and again, I was at the deposition along with counsel, and it was recorded and is provided as attachment to the defense motion. What's the state's perspective on whether the court denied that motion because it was not a valid exercise of the Fifth Amendment? The defense, if I understand what they're written, and that's why they believe Ruiz is on point, is because the court found it was not a valid exercise of the Fifth Amendment in Ruiz, and the appellate court agreed with that. And I think the defense at this point, if I hear them correctly, is saying in this case, the court, me, also found it was not a valid exercise of a Fifth Amendment right during the deposition, and that's why the court ordered the witness to answer after asserting the Fifth Amendment multiple times. So what's the state's perspective about whether it was a valid or not valid exercise of a Fifth Amendment at the deposition?
The state's position is that it doesn't matter. They were exercising that right at the advice of their counsel, and all of the questions have been answered. What was going on in Ruiz is that the co-defendant wanted to use the exercise of that right as a shield to prevent anybody from getting the answers from him. And the court said, you don't get to use it as that shield. We're going to call you up there, and if the court finds it's not a valid exercise, you're going to have to answer those questions. That is completely different than what happened here, where all of the questions, the court found that the exercise was invalid, but it was at the advice of counsel, and then all of the questions were answered. So there's simply no reason to bring that up in front of the jury except to try to draw impermissible inferences from the exercise of a constitutional right exercised at the advice of counsel.
not all of the law enforcement witnesses that the state endorsed on their witness list exercise their Fifth Amendment. And because of that, presumably, and I wouldn't know this, presumably went through interviews with counsel and did not, or at least no one made a motion to the court to order a deposition of those witnesses, presumably because they didn't assert a Fifth Amendment right. So, and I don't need a number count, but is it accurate that some of the law enforcement officers that the state endorsed as witnesses did not assert their Fifth Amendment, and so were able to be interviewed by defense and the state?
Yes, Your Honor, most of those were, it was the 4 PCSOs, and Lieutenant Stark. And again, remember they arrived later at the scene, and they are not the subject. TPD is partially the subject of the lawsuit that's being filed. And I think it was clear when the attorneys were explaining to the court what they were concerned about, that was one of the things that they were concerned about. So those TPD witnesses are in a different position than the 4 PCSOs who came to the scene afterwards. They did not invoke, and Lieutenant Stark also did not invoke. Oh, that's true. But I should mention that every single witness invoked during the prior proceeding.
Defense.
Certainly a prosecutor cannot comment on the defendant's valid invocation of their Fifth Amendment rights, but what Ruiz says is that commenting on an invalid invocation is not a comment on a privilege. And we are not seeking to exploit any privilege. We're seeking to point out that Officer Lawless attempted to avoid answering questions and obstruct the defense's ability to gather information in the case. And the point here is that he did that just for the defense. When the questions began, so we asked about a meeting that he had with the Attorney General's office, and to every question he invoked. But when the state began asking questions, he did not attempt to avoid answering those questions. He answered them voluntarily. He never invoked, not one time. And he explicitly stated in his deposition that he was invoking indiscriminately to every question that the defense asked, and then he did that. So also, and that combined with the fact that he refused to sit voluntarily for a defense interview, and the fact that he met with the Attorney General's office and did not invoke his Fifth Amendment at that, all of that goes to his bias in this case and his credibility. And a witness's bias and credibility strikes at the very heart of a defendant's right to a fair trial. And that's what Ruiz stands for, and that's what we're asking the court to permit.
Okay.
Your Honor, it is simply not correct to frame, this is exactly the problem. They're wanting to frame this as Detective Lawless obstructing this defense investigation when the defense knows and the court knows that the state had to call a prior proceeding and bring in all of the witnesses and force them to testify under oath where they were represented by counsel and where they invoked. The state did that before the defense was even involved in this case. It is simply not accurate to claim that Detective Lawless was obstructing the investigation specifically as it pertains to the defense, when we're literally talking about a couple of questions where they were asking about whether they had met with us afterwards. And I asked like 2 questions which were clarifying questions, and that were answered. I was going to ask why do they want to bring it in, and now it's clear it's not a negative inference. They want to improperly argue that this detective was obstructing their investigation. And I think that's completely improper.
This is to the state. For the law enforcement personnel that invoked at the prior proceeding, were there at least some of those law enforcement personnel that thereafter were willing to be interviewed by the defense and the state without requiring the court to order a deposition?
Yes, they all invoked at the prior proceeding, and then the 5 that I named did not.
Okay.
But I'll point out the prior ruling was that the other officers who invoked was that that would not be brought up, so I'm not really sure what the difference is here.
Oh, okay. Mr. Gross, anything else?
No, you're not.
No. I do want to make a record about some of the events that occurred in this case. And so, and this is concerning specifically Officer Lawless. And I recognize we talked about a few of the other officers, but this is the defense motion specific to Officer Lawless, so my comments are specific to what I believe has occurred or did occur with respect to Officer Lawless. And so it is accurate that the court received information. I'm relatively sure it was from the state, but the defense, I don't think, disagreed that with respect to Officer Lawless, that a deposition would be needed before he would be willing to submit to an interview by anyone. And so that agreed, I'm pretty sure it was agreed order by the parties, was presented to the court, and I signed an order ordering Officer Lawless to appear for a deposition under the court rules as permitted by the court rules. And then at that deposition, although really rare, and I had some misgivings about it, the parties provided case law to me suggesting from an appellate court that it would be wise for a judge to be at a deposition so that I wouldn't have to be called during the whole deposition in my office. And so somewhat reluctantly, but the appellate court ordered it so in another case, and so I appeared. During Officer Lawless's deposition, his counsel was there, and his counsel presented on the record the counsel's legal analysis concerning why the Fifth Amendment should apply and why his client, Mr. Lawless, was properly asserting the Fifth Amendment. And in just looking at the transcript of the deposition that's attached to the defense motion, there is a lengthy discussion about this. It's actually a shorter discussion on pages 15 to 17 of the transcript, and then pages 21 and then 29 through 34. And there was a discussion. Mr. Troyer's lawyer spoke, the state lawyer spoke, and then as did the attorney for Officer Lawless. And in looking through my notes and what shows here, Officer Lawless's attorney's theory that was parroted by all the officers who were deposed, it was a similar theory, was that it is currently now the climate that it can be difficult for law enforcement and Officer Lawless, but this is true with the other officers as well, was concerned that potentially something that might have happened here during this incident would expose them to criminal liability. So not civil liability that's been talked about, but criminal liability. And so that's why the attorney offered that. I went through a rather lengthy discussion of various case law in Washington and federal case, well, the United States Supreme Court case law, about when an individual properly exercises a valid Fifth Amendment assertion. And in particular, the court did cite to the case of State versus Fish, 126 Washington 2nd, 283 at 290. It's a 1995 State Supreme Court case that states the danger of incrimination must be substantial and real, not merely speculative. And I had asked Officer Lawless's counsel to explain to me what crimes could be charged or where it would be, and he gave a general answer that it was possible the state could charge this individual and cited some federal civil rights criminal statutes as well as potential Washington state statutes. The court found, based upon that quote in Fish, that legal argument about assertion of the Fifth Amendment was not substantial and real. It was speculative. And
May I interrupt for a moment? My client needs to take a break for health reasons. This alarm's going off.
yes, we talked about that. Yes. So we will stay. You may take a break. I'm going to stop, but we can stay on the record if it's just going to be a couple minutes.
Yeah,
yes. Yeah, please take care of that. We'll keep the live streaming going as well. And I'm keeping the technology going because it can be difficult if we turn it off and turn it back on again. So we are on the record. We are live streaming to the public. The media is here as well. So just counsel should know that.
Thank you.
returned and we're ready to proceed.
Thank you. And so the court was discussing State versus Fish, indicating that the danger, in this particular case concerning Officer Lawless, that the danger of incrimination was not substantial nor real and was merely speculative. And for those reasons, the court ordered Officer Lawless to answer all of the questions to which he had asserted his Fifth Amendment privilege. The court found, and I'm finding today, that that ruling was based upon the court's determination that there was not a valid assertion of a Fifth Amendment privilege by Officer Lawless. Now, the state may be right that he chose to exercise that based on his conversations with an attorney, but the reason why he asserted is not the issue with respect to whether it's valid or not. And Ruiz talks about it's the court's decision to make that decision, that determination, not a witness, and so it was not a valid assertion. That's significant here because in Ruiz, the entire case is about a situation where a witness asserted their privilege and didn't want to answer questions, but it wasn't a valid assertion. And the court found that under that circumstance, there would be no violation of the Fifth Amendment's the Fifth Amendment right privilege against self-incrimination by the witness because there was no privilege being exploited. And it's the concern that a party would improperly exploit a Fifth Amendment assertion in front of a jury. That wasn't the case in Ruiz because there was no Fifth Amendment privilege to exploit because there was no Fifth Amendment privilege, which is what the court found here at the Lawless deposition. So what are we left with? Well, the court doesn't have any concern about exploiting the Fifth Amendment privilege of Officer Lawless, again, because he didn't validly assert it. This defense is citing to State versus Orn, a case which, ironically, the court provided to both parties, which is our state Supreme Court making crystal clear to trial courts that defense is going to get a wide berth with respect to cross-examination on bias and credibility, particularly with respect to a material witness in a criminal case. And that case guides the court's ruling today. The defense is going to be permitted to inquire about the assertion of the Fifth Amendment. It required the court to have to appear for an order deposition and appear for a deposition when there was not a valid basis for that assertion to occur. The defense wants to argue that to show bias and credibility as permitted by Orn. They would be permitted to argue that. Now, that doesn't mean the state can't come back and say, well, and have further questioning as to why the officer exercised, because there's been discussion that he talked with his lawyer. I'm not going to let anybody ask questions about what the lawyer said, but if that's ultimately what this witness says, it was based on the advice of counsel, well, so be it. But that doesn't mean the defense should not be able to get into this inquiry. And I should say, at least, and this could be just my limited experience where I happen to work in Kitsap County, it is an extremely rare event for a non-suspect law enforcement officer to assert the Fifth Amendment. That's an extremely rare event. And in this case, it was not properly exercised. And so I don't recall whether it was a defense motion in limine for me to reverse my ruling or not, but I want to make clear the defense can inquire about what occurred with respect to the deposition, asserting the Fifth Amendment, and then the witness is going to answer whatever he chooses to answer. And if clarification is needed, please ask, because I want to make sure I'm clear about what this ruling permits.
I'm not clear. We had a pretrial ruling that this wasn't going to be permitted, and I guess I'm trying to figure out what's changed. I made a pretrial motion to keep any comment about the assertion of the Fifth Amendment right from being gone into the witnesses, and the court granted that. So I'm trying to figure out what the distinguishing point is, and given that it's 3:30, we're going to ask to brief that. Because
go ahead.
Well, I'm not sure what's changed here.
Well, you didn't provide the court with State versus Ruiz. The defense did.
So
Had that been provided to the court, it may have been a different ruling. Ruiz is a particularly important case on this issue, and the state didn't provide it to me. And now I have it, and so what's changed is State versus Ruiz.
Well, Your Honor, then we would ask to brief this by tomorrow morning, because I also have case law in front of me. First of all, when I was quoting Doyle v. Ohio and United States v. Johnson, it was not talking about defendants exercising their rights. The first one was an individual's exercise of his right, so I would like to see what kind of individual that was. And then the second one is a witness's assertion, so I don't think that's limited to the defendant. And then it goes on to say, clearly a defendant would like to benefit from the inferences that the jury could draw from, in this case, his co-defendant's invocation of the Fifth Amendment privilege. But a defendant does not have the right to call a witness to the stand simply to force the invocation of the right against self-incrimination in the presence of the jury. Thus, the trial court is justified in refusing to compel appearance or testimony by a witness intending to exercise his Fifth Amendment right. And they are literally on record saying that because this witness followed the advice of his attorney, whether or not that advice was correct or incorrect, that they're going to get to argue that the witness who was following the advice of his attorney was obstructing a defense investigation. That is inaccurate and it is highly prejudicial, so we'd ask for a recess to brief that tonight.
Defense.
I guess three things. First, it sounds, I haven't read that case, so I won't say anything. But first is in response to the question that this was a pretrial motion and why is this being ruled on now. It wasn't a written motion that was filed along with all the motions in limine. The state made an oral motion at some point in the midst of the beginning stages of trial, and defense argued the state hasn't provided any authority. They just made sort of arguments consistent with the rules of evidence about why a person shouldn't be able to point out about the invocation. We said that. We said they haven't provided any authority, yet they're the ones moving to exclude. And then we told the court we'd like to look into that. We'd like to provide the court with authority if we can. So I just want to correct that portion of what happened. The second thing I want to say is that I need to correct something that's in our brief, which is a statement of fact that looks to me like is incorrect. It looks like in the court's ordering depositions, one of the court's findings of fact was that Officer Lawless's lawyer represented that his client would not voluntarily answer questions from both the state and the defendant. So I think in our brief we said that he refused to answer questions from the defendant. It sounds like it was from both. So I want to correct that.
Defense response to the state's request to be permitted more time to conduct legal research and readdress this issue tomorrow morning?
We would object to that. And again, it's because the state didn't produce or bring this argument to the court's attention in the motions in limine when the parties would have the benefit of full time to brief. Instead, they raised it as an oral motions in limine in the midst of trial, and we weren't given an opportunity to respond. That's what we've now taken, the opportunity to respond. We've provided the court authority. The court's made a ruling based on an educated and it seems like fairly thorough review of the case law, and I don't think we should delay this trial.
Your Honor, this authority was provided at 8:23 p.m. yesterday. That alone should give the state a chance to respond, especially at this late hour when even if we get started with Officer Lawless, we're not going to get very far. But I will also let the court know that where Ms. Serrano and I were working last night, there was a power outage, and we were not able to do anything for an hour from between about 9:15 to 10:15.
Is there a reason when the state made its oral motion to the court to prohibit any inquiry from the defense about the Fifth Amendment assertion by witnesses that the Ruiz case was not provided to the court?
I'll be honest, I thought this issue was a no-brainer. The case law is very clear that you cannot use the exercise of a constitutional right against somebody.
What about an invalid exercise of a constitutional right? Because that's what this case is. It's not about a valid. I completely agree with you. You and I are on the same page with respect to a valid exercise of it, particularly with respect to a defendant, but even witnesses, that would be true. Because the jury shouldn't be allowed to speculate on a valid assertion, or one might be reluctant in asserting the Fifth Amendment. But that issue is not before the court. The issue is an invalid exercise. And so I don't want to cut you off on what you're arguing,
No, I know
but you're
that.
arguing about what the Constitution says with a valid exercise is irrelevant to this discussion about an invalid exercise that I found Officer Lawless and the other officers invalidly exercised their Fifth Amendment privilege. So there's no risk of that exercise of the privilege being exploited by a counsel or the jury because it wasn't validly exercised.
But it is being exploited. Your Honor, whether or not the exercise was valid or invalid is a decision for the attorney, Mr. Staropoli, and I'm not criticizing anything that he did, but he made a decision about whether or not to try to invoke, and clearly he would have thought that there was validity as he argued vigorously to invoke this. And whether or not that was valid or not, it has nothing to do with Officer Lawless. And now they want to take a decision, whether that is a correct or incorrect decision by his attorney, and they want to take that decision to paint him as somebody trying to obstruct a criminal investigation. And that is incredibly prejudicial. Officer Lawless didn't do anything here except follow the advice of his attorney.
Ruiz at paragraph 28 states, quote, "The inference to be drawn from a refusal to answer is that the witness is protecting someone, not that the inquiry is substantive evidence of fact." Here the potential, if in fact that's what Officer Lawless was going to say, was he's trying to protect himself. But he's trying to protect somebody, and that's what Ruiz seems to be talking about.
You're right, this was a co-defendant case. This was a co-defendant who didn't want to answer questions on the stand, made up an invocation, and the court said, you can call him. You can't use the Fifth Amendment as a shield to not answer questions. Here, Officer Lawless followed the advice of his attorney.
But why doesn't that go to the weight to let the jury hear that and decide that, as opposed to me saying that that should not come to the jury to begin with?
Because they're going to argue that his testimony is somehow not credible because he followed the advice of his attorney.
And then you could argue, well, that's ridiculous. He followed the advice of his attorney.
Well, if
And
it's
let the jury weigh
ridiculous,
it.
then why is it relevant? The
Because of
negative
Orn.
inference here is overwhelming. Officer Lawless did not ask to be dragged into this case, and now they want to put him on there and argue that he's a law enforcement officer who doesn't want to tell the truth.
Well, counsel, the state's calling him, not the defense.
I think that's a distinction without a difference. This court is allowing them to argue that he is not credible, that he is biased, that he is obstructing an investigation because he followed the advice of an attorney, which he is entitled to do. How does following the advice of an attorney impeach his credibility? I mean, that's really the central issue here.
No, the central issue is he trying to protect somebody under Ruiz on paragraph 28? Is the witness trying to, like the co-defendant, in that case, the witness was trying to protect the defendant, but in this case, is he trying to protect someone else?
But Your Honor, in Ruiz, that person was on trial. That is a co-defendant. Ruiz is a co-defendant case. Officer Lawless isn't on trial. This was
But if it's true, well, I think it was a co-defendant who'd been sentenced, and so the reason why there was no Fifth Amendment privilege was because his case was over. But if it's permitted in a co-defendant case where we're certainly, the law wants to protect people charged with crimes, why would a witness who's not charged with any crime be more of a concern rather than less of a concern? Because you want to protect the rights of people who are charged with crimes, and Mr. Lawless certainly is not.
Your Honor, I don't know in what universe an officer will get up in a high-profile case with the cameras rolling and be accused of obstructing an investigation, trying to hide something, trying to defend himself from God knows what, how that isn't close to slander.
In an open courtroom.
Yes.
Is there not a First Amendment right, privilege with respect, a First Amendment right with respect to what occurs in an open courtroom for both
Yes,
parties?
There's also a Fifth Amendment right to assert the privilege against self-incrimination without being punished for doing so.
If it's validly asserted, I agree with you. It's not validly asserted in this case.
But that's not a decision Officer Lawless made. That's a decision his attorney made. and
No,
should
he
not be
exercised the Fifth Amendment. His attorney did not. It was his right to exercise, and he exercised the Fifth Amendment, not his attorney. In fact, his attorney could not exercise the Fifth Amendment. That was the choice that Officer Lawless made, nobody else.
That was the choice his attorney made, Your Honor.
No, that's their counsel.
Your Honor,
You're-
these are
you-
legal
it's-
arguments that the witness isn't going to refuse to follow the advice of his legal counsel. He's not educated in the Fifth Amendment or constitutional rights.
And again, why doesn't that go to weight?
Because they're going to use it to argue he's hiding something when he's not.
And how do I determine that fact? How do I determine the fact that you say he's not hiding something when he asserted the Fifth Amendment improperly? How do I decide that fact as opposed to the jury?
Your Honor, even if this is relevant to his credibility, which the state does not believe it is, this is highly prejudicial. They are going to try to paint this 15-year officer as obstructing a criminal investigation, and that is improper based on following the advice of his counsel.
Anything else?
Just that we'd like to brief it tonight.
Anything else from the defense?
No, we again object to the state getting an opportunity to brief it tonight, because the reason that there wasn't an opportunity for either party to brief this earlier is because they didn't raise it in the motions to eliminate, according to the court's order.
Your Honor, they could have filed Ruiz 5-6 days ago. They filed it last night at 8:23.
Well, you could have filed it in the motions in limine, but you didn't,
Because we had already won.
with no case law. I mean, what I'm learning from this is I made a mistake. I shouldn't have granted that. It seemed logical to me with respect to the Fifth Amendment like you're talking about. Ruiz has changed the court's perspective. But the court's going to grant the state's motion. I'll give you overnight to provide any of their case law. If you do at this point, it either needs to be in writing or just copies of the cases and highlighted what you want the court to look at. And then we'll address this tomorrow morning.
And provided to the defense.
Well,
Thank you.
I should have said that, of course. And counsel will, the state would certainly do that. Anything else from the state?
No, Your Honor, thank you.
Anything else from the defense?
No, thank you.
Court will be at recess, and please be ready to go by 8:45 tomorrow morning. And let's see, the jury. Before I'm going to have the jury brought out because I want to read them the instruction after the recess, and so please stay here, don't leave, and I'll bring the jury out.
Oh, I know. Fine.
The jury is returning to the courtroom. Thank you. Everyone may be seated. Members of the jury, it's getting a little bit late in the day, and while there's a little bit of time left, I've decided that I'm going to release you now rather than have you stay any longer. So, you've heard this before, and you're going to hear it again. During this recess and every other recess, do not discuss this case among yourselves or with anyone else, including your family and friends. This applies to your internet and electronic discussions as well. You may not talk about the case via text messages, email, telephone, internet chat, blog, or social networking websites. Do not even mention your jury duty in your communications on social media such as Facebook or Twitter. If anybody asks you about the case or about the people or the issues involved in the case, you are to explain that you are not allowed to discuss it and you can blame me. Do not allow anyone to give you information about the case, including in your electronic communications. If you start to overhear a discussion or receive information about anything related to this case, you must act immediately so that you no longer hear or see it. If you become aware that you or another juror has been exposed to outside information, you must privately notify the clerk. Do not discuss these matters with the other jurors. Do not read, view, or listen to any report from newspapers, magazines, social networking sites, blogs, radio, or television on the subject of this trial. Do not conduct any internet research or consult any other outside sources about this case, the people involved in the case, or its general subject matter. You must keep your mind open and free of outside information. Only in this way will you be able to decide the case fairly, based solely on the evidence and my instructions of the law. Have a great evening. Please be back in the jury room by 8:30 tomorrow morning. And thank you for your attention today. The jury is excused at this time. The jury has left the courtroom, so thank you, everybody. You may be seated. Anything else from the state?
No, Your Honor, thank you.
Anything else from the defense?
No, thank you.
Thank you, everybody. The court is at recess. We will please be back here in time to start court